Ready.
He's saying we're on. Does it say on?
When the light comes on.
I know. He gave me a thumbs up. I don't know what that means. Oh, we are on air. The light's not working.
Oh, so we have
Let's give
to
you
be
a fun
careful at
beginning of the
end.
video. Yeah, let's make sure we're off air. We don't say anything off air, John. We're fine. Okay. We're going to start the June 26th, 6:30 p.m. Sewer Commission meeting in accordance with the requirements of open meeting law. Please be advised that this meeting is being recorded and broadcast over Lunenburg Public Access. Adam, do I even have to say that? Are we going to learn about that? Announcing the open meeting law thing, is that actually a part of it? Oh, come on. Every time. So anyway, announcements? Probably anything?
I do not.
I don't have anything.
Well, we sent out demands today and for any past dues.
Okay.
This is the last quarter of the fiscal year, so if there were inserts with those demands saying that anything now past due that goes through to December will be put on their tax bills.
Okay.
So, trying to get them to pay.
All right. Please pay, Bob. Current business. Let's see. What am I working? This is my working journal. Appointments. We have Adam Costa here. He's going to do the open meeting law presentation. Adam, if you're not ready, I can do public comment first, and then we can get into it. That's fine. Do that. All right, we'll do public comment first. Anybody public comment from the board? No. Okay. Public comment from the public. All right, Adam. I bought you 6 seconds.
Move some of these so we get a clear shot. Problem is I don't know whose screen that is because it's not mine.
Oh. Is there a remote for that? To switch it over?
Just lost your video.
We got a source button, so let it boot up again and we'll give it a try.
I can do the minutes real quick. Everybody look at the minutes of 6:12.
Yes.
Everybody look at them. Any changes?
I have one comment. I don't have it in front of me, but
I didn't print
do you
the
have a
minutes.
Thank you, John. On the paragraph talking about Bob Proctor, Lancaster Ave Extension, everything that's there is okay, but I would like to suggest we note that the question of privilege fees came up, and that there was a request to review privilege fees as they relate to, privilege fees, and what the value should be based on. So I
Could
just
say
wanted- I just
privilege fee. Does commission discuss the privilege fee for a private extension, and we'll get clarification from town council?
Yeah.
I think that's what that was. We left off privilege.
So add privilege fee to that sentence.
Would that work?
That works for me. Does that work for everybody else?
Yes.
Anybody else have anything?
Yep, that's good.
Okay.
Anybody else? Okay,
Thank you.
take a motion to approve with Carl's amendment.
So moved.
Anybody second?
Second.
Any discussion? All in favor?
Aye.
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 Okay. Bob, what's this FY18 budget consideration? Is that a long thing or is that kind of quick?
Nope, that is just, I know Heather and Karen had come and spoke before the commission about the legal payments and how it was set up this year with Mead, Tollerman, and Costa. We had set up, as we had for KP Law, we had set up a PO for them, not knowing at the beginning of the fiscal year how it was going to net out. I'm just putting forward, right now we're doing end of year and looking at it, and there's still 1,000 on there. So I didn't know if there was any consideration to put some towards the town, because the general fund has been covering the cost. So it's just a thought. We had set up the PO thinking it would be billed like we were with KP Law. So it was just an idea just to discuss before the end of the year when it's gone.
So the idea to pay $1,000 towards the MTC expenses for FY18
Or any amount
or any amount.
thereof.
Anybody have any thoughts on it? Or want to discuss it?
Well, I never liked the any amount thereof. So, and so we've got 1,000 left of what we budgeted, if I
Right.
understand.
Right. We'd
But
created-
KP Law is still working for us, right? So,
KP Law is separate. We have that money and that will be encumbered because that's for the Highfield. This is Mead Tollerman. At the beginning of the year, we weren't certain how we were to be billed for council when we were doing the budget.
yeah,
And then the start of the fiscal.
remember
that's next year, though. That's next
No,
year.
no, this is current year. This was 7/1/17 when council was switched over from KP Law
Yeah, this
to
was
Mead
separate money
Tollerman.
we put aside for that. Yeah, I remember that.
Because we only were going to use KP Law for Highfield.
Correct.
So,
So what money is set aside for KP Law?
not the money for Highfield.
Yeah, what money is that? I don't know what that
The
money
money
is.
that was left from the budget at the beginning of the year, the money that we're expecting to pay them for finalizing the Highfield agreement.
But do we know what that is?
I can only encumber what was set aside in the beginning of fiscal year 18.
Yes, for the amount,
And it has nothing to do with the 1,000 that's been
Right,
set
it has
aside for
nothing to do with
Mead
this. We
Tollerman.
set two different monies aside. Am I correct, Barb? I remember doing this.
Right.
Yeah, we set two different monies aside. They're not even in the same, for the same thing.
Right.
They're separate accounts.
Yeah, you're right.
Well, yeah, it's all legal counsel, but
Yeah, but they're,
one was earmarked for the
yeah,
Highfield.
we
Right.
separated ourselves.
So it's just a,
Do we have to make that
consideration.
decision tonight? Because I'd like to look at the numbers and understand it.
no, we can do it at the July 10th meeting when we finalize encumbrances. Do you want me to encumber it? I have to draft encumber now because we don't meet again until after the town manager's deadline. So I can put it in there and just say it's up for discussion.
Yeah,
Okay.
I'd like to understand it.
Let Carl get it and we'll do that one. Still not working for you?
No, fine.
So that's not your screen?
No. I'm not sure what screen that is.
Is that an HD in the middle there? Is that yours?
It is.
Is that to your computer?
Yeah, HDMI to HDMI.
Into Wi-Fi somewhere? Or get somebody else's computer?
Did it go through the search? I didn't see it go through the search, but I wasn't looking.
It says computer 1, computer 2 on the top. Have you got the right computer?
Yeah, and I've got HDMI. which-
Yeah.
It has an HDMI plugged in, so that should be on.
If you go to the bottom and hit one of those icons, what happens?
Is it usually showing your screen?
This isn't his computer. This is somebody else's screen on the
All right.
It is and it isn't, because when I click on the actual, see the highlight down below?
Yeah.
So it's,
It's just very strange.
Do you have to duplicate screen? Do you see what you want on yours,
It's the background on
right?
your computer.
It is, but I'm not seeing any of the actual,
Try clicking on those icons on the bottom. I'm telling you, that always works for me. I don't know why.
Or maybe if you, right-click the Windows icon to,
Yeah, the
let's say,
Windows
switch
icon.
computer or switch user or something.
there we go, PCs.
Yeah. There we go. It's searching.
Now it's searching.
We're good.
Feeling pretty confident?
Yeah, I'm feeling very good.
You've only done this a number of times. Yeah.
Why not?
Well, can I give a partial update on the recommendations? I got commission approval to start collecting, which I haven't finished because some people are on vacation now, or now?
Recommendations.
It's not on the
Yeah, it's not on the
agenda.
agenda.
Okay,
But,
it's
so
not-
you could do it, but there couldn't really be a discussion
No,
because.
I could make a public comment about it.
There you go.
I started calling the references from the Badger Styles folder, the presentation on the cellular data collection for irrigation meters.
That was it, we just came up, yeah.
Gary's got it, okay.
Thanks, Joan.
Good job.
Started.
Yeah.
I got 2 out of 4.
That's all right. We got a public comment coming up anyway.
So surprising I'm not seeing it on my screen, but I can see it on the big screen. So I guess that's a little-
Jeez.
What are you trying to do?
Make it full screen so it's a little larger for you. Okay. Ready to go?
Beautiful.
Yeah, go ahead.
Great. So, thank you all for making the time on your agenda tonight. As you know, this is an open meeting law presentation review. It's meant to be somewhat less formal or more informal than the presentations that are often given, the trainings that are often given by the Attorney General's office.
You have a mic.
I think that in a small setting, certainly I invite any of you to interrupt and to interrupt and to ask questions as necessary, when necessary. Just stop me. Really, this is an overview, as you might imagine, with the open meeting law. You've got the statute itself, you've got the regulations that were thereafter promulgated that fill in some of the gaps in the actual statute, and then you've got dozens, hundreds of decisions that have been rendered by the Division of Open Government that further define what does and does not constitute a violation of the open meeting law. So this is meant to be a somewhat comprehensive overview to incorporate statute regulations and some recent case law. So the administration of the open meeting law is done by, as I've referenced already, the Attorney General. There's a new division entitled the Division of Open Government that was created a number of years back when they recodified the law, that is now responsible for the administration and enforcement of the open meeting law. The regulations that the Division of Open Government has adopted are found at 940 CMR, which stands for Code of Massachusetts Regulations 29. They're comprised of a number of sections, and the regulations deal with certain issues that aren't dealt with in the statute. So if you've got questions about, for example, remote participation is addressed almost exclusively in the regulations. If you've got questions about keeping meeting minutes are addressed almost exclusively in the regulations. So you really have to look to both the statute and the regulations if you're looking for a topic to see whether it's addressed in one or the other. So there are a number of definitions that are of some importance in the open meeting law, and you'll see they're referred to throughout the presentation. The first one, and maybe the most important, is what is a public body, and therefore what sorts of entities are subject to the open meeting law. Public bodies include all multi-member boards, committees, commissions, etc., that are established to serve a public purpose in the town, including subcommittees created to advise or report to the full public body. We'll address a bit later, although I guess I'll just touch on it now while we're in the definition, the concept of a subcommittee. I often caution municipalities and public bodies and boards like yours just to be mindful of officially designating a subcommittee. It's one thing to say, we're going to have a working session with a particular applicant, and we're sending a couple members are going to go and report back to the board at the next meeting. That's okay. A couple of members of a 5-member board is not a quorum. You're okay. If you begin formalizing that process and appointing those two individuals as a subcommittee, whether you use that term explicitly or not, you can potentially run afoul of the open meeting law, because now that subcommittee is itself a public body and is subject to the open meeting law, and 2 members of that subcommittee constitute a quorum of the subcommittee, and now their meetings need to be posted. So not something that arises with too much frequency, but my recommendation to public bodies generally is just be informal when you're going to have a working session or a working group, and having a couple of members go and just report back to the board at the next meeting.
Adam, I have a question on that.
Sure.
So this would mean if we had just a working group and a couple members went and explored something, they're not a decision-making group. They come back to the commission for decisions.
That's correct. And so this is done often with larger projects. I don't see it too frequently with, boards of health or sewer commissions for that matter. I see it with zoning boards of appeals that have, Chapter 40B affordable housing projects that come before them. Those reviews can be ongoing for 6 or 8 or 10 or 12 months. And sometimes going through the nitty-gritty of an engineering report and trying to propose certain site revisions to an applicant and get feedback from its consultants is somewhat tedious to do in an open meeting with 300 people in the audience who really want to have an opportunity to be heard. And so what often occurs is they'll schedule work sessions between public meetings. And the idea is that nothing is going to happen there that isn't going to later be a subject of a discussion before the full board. And therefore, those meetings can occur behind closed doors with 1 or 2 representatives of the board attending. Very often it's just one. But then you're going to come back to the board for an update, and there's no decision being made of any matter of substance, because there isn't any matter of real substance before those representatives.
Thank you.
So deliberations is another important term in the open meeting law. What are deliberations? So they're any written or oral communications, including communication via email and or other electronic medium. So think about Facebook, think about Twitter, think about other online forums for exchange of public information between or among members of a public body on any public business that is within its jurisdiction, not including the distribution of meeting materials, scheduling information, or reports/documents to be discussed at a meeting. And I'm going to offer a point of clarity here, and I tend to sometimes get ahead of myself in this presentation because I hate to just gloss over a definition like that and not stop and say, all right, so you see reports/documents there, and you say, well, that's great. We do that all the time. We've got members of our board that create documents, and they circulate them amongst the board, and it's A-OK. Well, that's not really what they mean when they say reports and documents. They're talking about the instance where you've got your third-party consultant that prepares a report that you asked for 2, 3, 4, 5 meetings ago, gets it to Barb, and Barb shoots it off to the full board, the full commission. That's acceptable. That's a report. It's not something that contains the opinions of any one individual member then being disseminated to the board. It's something that is generally from a third party, something that is generally an objective document that is being circulated just to familiarize the board with the substance of it before a meeting. And obviously, meeting materials will consist of an agenda typically. Scheduling information is exchanges of emails, for example, trying to find the date that works on everybody's calendar. Those are exceptions to the definition of deliberation.
Adam?
Sure.
I'm not a great reader, so maybe the word's there. I'm not seeing a tie to a quorum. Doesn't a deliberation require a quorum?
Not yet, but it's
not
it's
yet.
here. Yeah.
Sorry about that.
Okay. I want to make sure that.
But if we don't need it in the definition, then any communication is a deliberation?
No, because it later goes on to define a meeting. So
Okay.
when you get into the definition of meeting, it's a meeting that constitutes a quorum. And of course, the deliberation in a meeting is what is a violation of the open meeting law.
Okay. A deliberation in a meeting.
Right.
Okay.
So intentional violation, and this one's here, we'll get to it a bit later, but it's a concern for members often. What's a violation? What's an intentional violation? Because there are different standards in terms of remedies and potential relief that the Division of Open Government has against municipalities that violate or continue to violate the open meeting law. Intentional violation is an act or omission by a public body, and knowing violation of the statute or the regulations for that matter. Evidence of an intentional violation shall include, but are not limited to, the following examples. Number 1, acting with specific intent to violate the law. Number 2, acting with deliberate ignorance of the law's requirements. Number 3, previously informed by receipt of a decision from a court of competent jurisdiction or advised by the Attorney General, and then essentially partaking in that same conduct again once you've been put on notice. And so it says in the last sentence here, where a public body or a public body member has made a good faith attempt at compliance with the law but was reasonably mistaken about its requirements, such conduct will not be considered an intentional violation of the law. There used to be an additional catch-all here in this provision that they took out which made me happy, that said, when you rely upon the advice of municipal council, you're all set. They've worked it in elsewhere, but it's not part of the definition any longer. So you can't hang your hat on, oh, I talked to Adam, he said it was okay. All right, so here we go with the definition of meeting. So meetings are deliberations of a public body, but do not include the following, provided that no deliberation occurs: an on-site inspection of a project or program, attendance by a quorum of a public body at a public or private gathering, including a conference or a training program or other sort of media or social event, attendance by a quorum of a public body at a meeting of another public body that is comply with the notice requirements of the open meeting law, so long as the visiting members of the body communicate only by open participation in the meeting on those matters under discussion. That tends to be a bit of a trap for the unwary there, thinking that you don't need to post it because you're attending the meeting of another body, but then you are in the corner sort of huddled, communicating amongst yourselves. If you're going to do that, you need it to be an open meeting and you need to have it posted. The meeting of a quasi-judicial board or commission held for the sole purpose of making a decision required in an adjudicatory proceeding. That one, and I've said this in my other presentations, is something often that boards like planning boards and zoning boards of appeal in particular jump on and say, well, this is excellent. Now most of our meetings are no longer public meetings because we always are acting in an adjudicatory capacity. Unfortunately, the division has interpreted item D to apply only to state agencies. So municipal agencies don't benefit from that. And then E is just the catch-all for town meeting. When you're having a duly noticed town meeting, there's no obligation that you notice those as individual meetings of every board that's attending the town meeting.
I have a question.
Sure.
So on AgCom, there's 5 members. And so on Sunday for Farmers Market, there's at least 3 or 4 of us there.
Mm-hmm.
I mean, chit chat, it's not about anything, it's just about day-to-day activities. But we're there and we're doing farm-related things.
Right. So the question is going to be, are you discussing anything that is within your jurisdiction as the AgCom? And it sounds like the answer is no. It sounds like you're chit-chatting about, casual conversation, what you did yesterday, what you're doing tomorrow. You might chat about farm-related things, but nothing that is, but you have to be careful because due to the nature of who you are and the sort of business that you're in, there's a bit of an overlap between what your jurisdiction is and what you do in your free time, right? And certainly if you had somebody who wanted to file a complaint and was looking closely and happened to overhear a conversation, they're going to argue that you're having those discussions. And usually the way that gets discovered is, and maybe it's unintentional, your casual conversation tends to briefly turn to something that's going to be on the agenda for the next meeting. That's fine. There's nobody there to overhear it. But then you show up at the next meeting and you all are up on stage and you quickly proceed to something and you're too much in sync. Or you're not discussing something. You quickly move on to a vote, and to the average onlooker who wasn't at your conversation at the farmer's market, they're wondering how you reach that decision so quickly. And when they start to dig, they find out it's because you strayed off topic when you were meeting at the farmer's market and briefly discussed the matter, and we're all in agreement and didn't need to deliberate in an open session. So just have to be careful. So meeting notices. I think it's safe to say, and there are errors that occur from time to time, but the law with respect to meeting notices is fairly well known now and understood. And once you establish a process and a procedure in your community, I see fewer and fewer issues with meeting notices. There were many of them when the law was first recodified, but now that municipalities have a form and they understand what needs to go onto the meeting notice and when it needs to be posted, I don't see too many violations with respect to meeting notices, but we get them from time to time. I had a case a year ago where for a year, a board in a town that I represent, and meeting notices don't come through us. We've got dozens of boards in towns we represent, so I don't see them. This was a fairly, call it a minor board that they don't meet with great frequency. I don't think I'd ever attended one of their meetings, but they've been issuing meeting notices on the same letterhead for a few years. The letterhead said, town of X, and didn't have the address of town hall. They weren't putting the meeting room where they were meeting. They were just putting the time of the meeting and the topics. And somebody complained because they didn't know where the meeting was. And you might say, well, get online, and they probably know where town hall is. They drive by it every day, but it doesn't matter. They filed a complaint and it wasn't in compliance with the law. So create a form and stick to it. Meeting notices need to be posted 48 hours in advance. That excludes Saturdays, Sundays, excludes holidays. Has to include the purpose of the meeting, The agenda and any other matters the chair reasonably believes will be discussed. Notice must also contain the date and time of posting and the date and time of any amendments to the posting. Often that occurs, that something pops up late and you add it to the agenda. You need to make note of that amendment. There's a bit of a catch-all there. From time to time, things do arise that are emergencies, things that the chair, quote, didn't reasonably believe would be discussed, or as the language of the statute says, reasonably anticipate. And there's some flexibility there. Again, I advise my towns to rely upon that in an emergency. You shouldn't be resorting with any great frequency to, well, the chair didn't anticipate it, so let's talk about it. You could argue whenever somebody raises something in a meeting that wasn't discussed with the chair first, the chair didn't reasonably anticipate it. That's not the real purpose of the exception. It's to give you the flexibility when something pops up to discuss it on short notice. We've had this happen, a late-breaking issue in litigation, and you find out about it the day before, and you need to get a sign-off from the board. You post the executive session 24 hours in advance. The chair didn't reasonably anticipate it. It's legit. Notice must be posted in or on the building that houses the clerk's office and must be visible to the public at all times. Many communities have designated their websites as their official posting locations so that they don't have to have message boards that are available outside of town hall in all conditions. So this is often a question, what's sufficient information regarding the topics to be discussed at a meeting that it reasonably informs the public of what is going to be discussed? So in one particular case from the Attorney General, the meeting notice stating the name of the applicant and noting it was a request for an extension of an order of conditions was found to be insufficient. The Attorney General said that all other items in the agenda were listed as public hearings, while the notice for the extension was not identified as a public hearing. It was simply identified as by the property address. So the failure to notice that the hearing on the extension was a public hearing constituted a violation of the open meeting law. I was surprised by this. I thought the AG went a bit far. I mean, I often get questions about the difference between a public meeting and a public hearing, but I think it was the inconsistency within the same agenda that really put up the red flag here, where they were noticing that, hearing, and then there's a fourth item on the agenda that is not identified as a hearing. Somebody might see it and say, oh, I guess there's not going to be an opportunity for public comment there, and they don't show up. Because all the other ones were identified as hearings, and then lo and behold, it was the same. It was a hearing. They just were sloppy when they prepared the agenda. The Attorney General's office also has recently noted that notice for an executive session must state, quote, all subjects that may be revealed without compromising the purpose for which the executive session was called. So I don't know what advice you got from your prior counsel, but I know, there are a number of us municipal attorneys in the state, and I know that some are of the opinion that all you need to do when noticing an executive session is state that you're going into executive session and state the specific purpose. So there's 9, or depending upon how you count them, 10 purposes for executive session. You say executive session for purpose number 3, and that's sufficient. Take your roll call vote and go into executive session. I take a more comprehensive approach because I'm mindful of this decision. And when I go into executive session, I advise my boards to be specific. If it's litigation, specify that it's litigation, specify that either litigation is demonstrably likely or it's pending litigation, specify the case that you'll be discussing, cite to the court and docket number. There's no harm in providing that information. You're not giving away any strategy in the litigation. You're just telling them that that's what you're doing. I was in executive session last night with your planning board. We were talking about the Settlers Solar litigation. It was on the agenda. There's no hiding that. Nobody knows what was discussed other than the members. I didn't reveal any of it. I didn't compromise the purpose of the executive session. So more is preferred, so long as you're not compromising privileged details. On the flip side, the Superior Court recently overturned an Attorney General decision which found that a board had violated the open meeting law by failing to identify the names of litigants and unions prior to entering into the executive session. It said that the AG's interpretation that these details were necessary was nowhere in the statute and was essentially applying a standard that wasn't found in the law. So again, I think that case is the case that other municipal council rely upon when they say, oh, you don't need to bother putting the name of the lawsuit, but that's that. Alternative notice posting. I mentioned before that municipalities can adopt their municipal website as an official method of posting notices for meetings. There's a grace period for compliance in the event that a website is disabled. If the website is disabled for less than 6 business hours, the meeting can go forward. Otherwise, the meeting is to be canceled. The obvious reason for that provision is because, unlike going outside and posting the notice on a message board, as we learned earlier tonight, technology can be challenging. I touched before on the 48-hour posting requirement and the fact that in emergency circumstances it can be waived. Emergencies are somewhat different than circumstances where the chair doesn't reasonably anticipate. The idea behind an emergency is that you've got some sudden, generally unexpected occurrence and immediate action is required. Emergencies are what they sound like. If it can wait to the next meeting, it should wait to the next meeting. If it can wait till there is a special meeting called with appropriate notice given, it should wait till a special meeting is called. But there are those circumstances where it simply can't happen. Conducting the meeting, the chair must announce at the start of the meeting whether there will be video or audio recordings made, including those by private individuals. There's a requirement in the law that private individuals notify the chair if they're going to video or audio tape a meeting. But then the chair has the same responsibility if that hasn't been stated. Obviously, if somebody gets up at the start of the meeting and says into the microphone to the chair, "I'm recording the meeting's on notice." But if somebody comes up to you in advance and says, "I'm going to be recording the meeting," you can say, "Okay, thank you." You then have an obligation to notify those in attendance at the meeting that the meeting is being videotaped. To address a meeting of a public body, permission of the chair is required. That's we put that on here because it's a question that we get often. How do we maintain decorum in our meetings? And, I know that this is a problem, again, with, I don't even want to say with certain boards and commissions or committees, but really with certain projects. I don't know with what frequency you have a dozen or a few dozen people attending your meetings, but you've got boards like ZBAs when they deal with controversial affordable housing projects, or in some communities marijuana has been a hot topic, and so you've got these meetings and you've got dozens of individuals, hundreds sometimes in the audience, and things can get a bit unwieldy and people think they have the right to speak. Well, they can only speak with the permission of the chair. There is an opportunity in the public hearing context for public input, but it's always with the permission of the chair. I mentioned before that in the open meeting law regulations, there is a reference to remote participation, which is something that was added in when they recodified the open meeting law. In recodifying it, in addition to doing things administratively, like creating the Division of Open Government and providing for a new process and the ability for advisory opinions and things of that sort, they also addressed the realities of doing business in today's world. So they've added in, for example, to the definition of deliberation, as you saw earlier, that explicit reference to email communications or communications by other electronic means. Well, similarly, they've recognized that in this day and age, I've got some boards where I represent, I've got a board where I represent one of the board members is a pilot. I represent a board where I've got two individuals who are, one's an architect and one's an engineer, and they do national projects. They're traveling with some frequency and they want to participate in meetings. And so they can participate. In one case, I've got a member that participates via Skype. In another case, I've got members who routinely participate by telephone. But there are strict provisions as to how remote participation can occur. You need regulations in your community that allow for remote participation. Those regulations get adopted by the selectmen and then qualifies authorization for all other public bodies within the municipality to utilize it. Selectmen have the authority to place restrictions on the use of remote participation, including the amount and source of funding if there are funds needed for purposes of facilitating that remote participation. If there's no phone line to provide for a conference line into the meeting location. The chair must determine that the member's physical attendance is unreasonably difficult. Again, the idea here is not to use it because the member doesn't want to drive 5 minutes down the road to get to the meeting. The idea is that the member is overseas or in another state and can't physically be here. Acceptable methods of remote participation include any technology that enables the remote participant and all persons present at the meeting location to hear one another and to hear one another clearly. So if there's an interruption, there's a poor connection, the meeting should be paused. You should get the person back on the phone. If they're not there for the substantial portion of the meeting or a portion of the meeting when a particular matter is being considered because they've dropped off or whatnot, then they obviously can't participate in that matter, and they may have lost their ability to vote depending upon where you are in the public process. So again, just in summary, minimum requirements: you got to have a quorum physically present at the meeting location. Members participating remotely and all others present must be clearly audible. All votes taken must be by roll call vote, obviously, because otherwise the person on the other end of the phone doesn't know who's voting or how they're voting. And then there's a procedure you've got to follow. Chair must announce at the start of the meeting the name of the remote participant and that the presence of that individual is unreasonably difficult. Remote participants may vote. They're not deemed absent for purposes of like the exception to the Mullen Rule that would prohibit you from voting on a multi-session public hearing. Remote participants may participate in executive session, but must state at the start that no one else is present or able to hear their discussion so as to preserve the confidentiality. And then anytime there's technological difficulties that make the use of that participation ineffective, the chair decides how to address the issue based on what I just said a moment ago about somebody dropping off, pausing the meeting, doing whatever is necessary to ensure that that person is participating. So, email communications. As we said before, deliberation is defined to include discussions via email of topics that are within a board's jurisdiction. These are deliberations and they violate the open meeting law. Email communications must therefore be limited to the distribution of meeting materials and similar information. I recognize that that is a very conservative stance. I said before that I think that meeting materials can be deemed to include, even though they're separately stated within the definition, third-party reports. But as your commission well knows, that there's a fine line there, and good intentions in getting information out to a commission in advance so that members can be educated, can be familiar with the matters that are on the agenda and how to address them. That efficiency sometimes runs counter to the requirements of the open meeting law, which say that anything that contains the opinion of a member when it's sent out to a quorum, even if it's a one-way communication, is a violation.
Adam, I have a question on that.
Sure.
So if I go through whatever information was given to us at a previous meeting and I make a chart and I organize all that data, that's still my work. I'm not sending that out to the commission before the next meeting saying, I did all this data analysis and I want you to look at it before the meeting because it's work I did, right?
So I think that would be my advice, and I think that is the safest approach. Now, I recognize, with anything, what's the old joke? If you ask, 10 lawyers the same question, you get 10 different answers. I think that, that's just the reality of it, that there our approach is to be as conservative as possible in providing legal guidance to, municipalities and to their boards and commissions and their volunteers to avoid violations. An argument could be made that you're not expressing opinions, you're simply regurgitating the same information that's been presented. You're presenting it in a different format to simplify it, but if you're not interjecting opinions, then that's not deliberation and that's legit, and you could circulate that even amongst the quorum of the body. But you can get nitpicky and start looking at it and saying, well, depending upon let's say you're putting items in categories, is the decision to put something in this category versus that category an opinion as to how you qualify it? It just, there's too fine of a line there. So I think the safest thing is to say, I'm just going to hand it out at the next meeting.
Put it on the agenda and hand it out at the next meeting.
Exactly, right.
Where's the word opinion in there?
We haven't gotten to it yet, but we will.
So pretty much email would just result in a calendar. That's all. There'll be no communication.
It's, right, so it's scheduling information, agendas, and documents, reports, other information
Third-party reports?
that might be considered that don't contain opinions of members. So generally, those come from third parties, because anything any of you create could potentially, and probably will in some manner, contain your opinion. But a lot of times, again, I keep going back to these examples because I'm thinking of big projects where you get a lot of information coming in. ZBA is reviewing an affordable housing project, and you've got a butter notices pro, a butter notices or letters con in opposition to the project. You've got the applicant's reports from its traffic consultant and its fiscal consultant and its environmentalist that come in between meetings. You've got your board's peer review consultants reviewing all of that information back and forth between them. You could have 50 documents that come in between, in a 1 month span between meetings. All of that can get circulated to the board in advance. None of that's generated by you. That's a lot of documentation going out in advance, and I think it makes a lot of sense to get that out so you're reviewing it. You don't want to get that packet as you walk in the door, but none of you should be reviewing it and making comments alongside each item and saying, we should talk about this at the meeting. Bring that to the meeting.
Is that a statement? We should talk about this? It's not really an opinion.
Right, but as I said, making comments next to each one. If you simply sent it back out and said, we should talk about this, that's fine. My point
And we should
was,
talk about the report as a whole, it's fine.
if you sent the report out as a whole and said, we should talk about this at the next meeting, that's fine. My point was going back to the comment I made about making comments alongside each of the items and then saying, hey, we should talk about this, and here are all my thoughts on it. You don't want to get those out in advance.
So, I'm still missing the connection to a quorum.
Yeah, it's not here yet.
Okay. So, but this isn't true unless there's a quorum involved.
That's correct. That's
Okay.
correct. It's with a quorum. If there's less than a quorum, then it's
Yeah,
not a
so-
violation.
So two
That's correct.
members can share emails and opinions and whatever else they want.
Two members are permitted to do those things. Again, and I'm not saying anything that I haven't said before. We always caution, and when I say two members, I'm speaking of two members of a 5-member board. Obviously,
Yeah, I'm sorry, yeah.
3-member board is a quorum and it's a violation. 2 members of a 5-member board communicating with one another is not per se an open meeting law violation. But the challenge can present itself when one of those members then communicates something that was said to that member by the other member to a third member, intentionally or unintentionally, or communicates it to a staff member who then passes it along to another member. So the general recommendation that I have is that if it can be avoided, don't communicate with other members of your public body about items that are within your jurisdiction, other than the exchange of reports and the other sorts of things that would be permitted amongst a quorum.
Okay. Yeah, I understand. 'Cause it's good guidance, and it's important guidance, but I always just like to differentiate when you cross that line.
Yes.
So it's great guidance, but you don't cross the line unless it's serial or some other things happen, which you can't control, and that's why it's good guidance, right?
And that's the right term, serial, and we'll get, there's a slide, I'm certain of it, that addresses serial deliberation, because that's something that's come up.
So I have, just on this subject though, because I'm looking at the Board of Selectmen policies, and it's a very different, that guidance isn't here at all. I mean, the Board of Selectmen policies, in the agenda, it specifically says that members of the board, town manager, or others who prepare background materials for a meeting should have such materials available by the close of business the week prior to the scheduled hearing. So that it's actually saying send out the information a week before, which is not consistent with.
Have it ready? I haven't seen that. Does it say have it ready, or does it say send it out? Because you might have it ready so it can be put on the agenda, or the staff member can make copies ahead of time. So you might have it ready, but sending out is a different thing than having it ready.
Yeah, it may be a little fuzzy, but why would anyone care if it's ready, if it's available a week before, if you don't do anything with it?
Well, because the staff member may need time to make enough copies for the meeting for the person, or it may not need to get it on the agenda.
Yeah, maybe. So we'll go to the next one. In the email section, this is the Board of Selectmen policies and procedures. And I'm not sure how broad, well, this is talking about by boards and committees, so this is email communications by boards and committees. It says distribution of a meeting agenda, schedule, or procedural information, or reports or documentations that may be discussed at a meeting generally does not constitute deliberation. So it's a little confused, because that's saying reports and things from members, so it might be something to look at, because it's a little inconsistent with the guidance. I mean, I think it's technically true from what you just said, but
Yeah, that phrasing, that last piece that you just recited, does mimic the way that the open meeting law reads about reports and documents. Even the open meeting law, until you delve deeper, doesn't clarify that, well, yeah, unless it's reports or documents generated by a member that contains member's opinion, in which case it's a violation if it's circulated amongst the quorum. I don't know when the selectmen's policies concerning open meetings were adopted. I don't know if they predate or postdate the recodification of the open meeting law. They certainly predate me. The reality is, regardless of what the selectmen's policies say, since the open meeting law has been recodified and since it's state law, the open meeting law controls. So you could have a selectmen's policy that says, we want to get all opinions of members circulated amongst all members of a board a week in advance, and you couldn't do it or you'd be in violation of the open meeting law. I don't care what the policy says. So, but you raise an important point, which is that if it's on the books, I know that the selectmen are quite good, at least in the short time I've been here, at trying to review those selectmen's policies with some frequency. In fact, I believe that they're in the process of looking through the policies now. So it may make sense to take another look at those. We addressed some of the issues, or at least I did, when I was looking through the charter, because it went through a couple of revisions as part of the charter review that ultimately never came to pass at town meeting, but obviously will at some point in the future. Ensuring that the few references that do exist in the charter to meetings are consistent with what the open meeting law requires.
Good. Okay, thanks.
And then the last point here on the side just says, it's suggested that all emails contain the following statement. This email is for the distribution of materials only, not for discussion purposes. I do this with some frequency. When I draft decisions on behalf of boards, and I do that with some frequency as well, and then I send those decisions out, I often send them out in advance of meetings to give board members an opportunity to review those decisions. And what I say in those emails is, feel free to respond to me and get me your comments, but do not hit reply all. In fact, often what I do is I email myself and I blind copy all the board members so that even if they hit reply all, they're only replying to me. And don't hit reply all, reply just to me with your comments. And then I've got to be cautious that if I get comments from multiple members of a multi-member board, and I do it even with 2 members of a 5-member board, that I don't take those comments, incorporate those changes into my decision, and then send a new version of the decision out, because now I've acted in that serial deliberation capacity. What I do is I take those comments in, I make revisions to the decision, and then I bring it to the next meeting, and I present it in an open meeting.
The liaisons excluded, even though they're CC'd on the emails. They can read, but they can't comment, or, because as my understanding, the liaison's role is cooperation and communication.
And by liaison, you mean like a business manager or a secretary or a clerk that's not a member of the public body. That's correct. I mean, they're not subject to the open meeting law because they are not a member of a multi-member public body. So they can participate in the discussion. They could, Barb could go back and forth with each of you on topics if she chose to. She just has to be careful to not be going back and forth with each of you, talking to you about something that she got from Joe or she got from Carl, therefore acting as the go-between to circulate an opinion of another member. Another recent decision by the Attorney General's office, there was a study committee created, a voting grid that addressed a number of potential issues. It was circulated via email to all the members of the committee. The Attorney General found that every email exchange containing a completed voting grid constituted an open meeting law violation, as it was an improper deliberation. Circulation of the blank voting grid was not found to constitute a violation. It was only once the members had completed the grid and then sent it back to the quorum of the body that it expressed their opinions and therefore was an open meeting law violation. Here's the concept of serial communication, and again, we've addressed that in past discussions. Serial communications are maybe the most challenging types of communications especially when they occur electronically, because they're often unintentional, but it's a series of communication that collectively represent an open meeting law violations. And then this last one, and we've talked about this one in the past too, and this is challenging. Expressions of an opinion of a member, even if no response is solicited or received, may constitute deliberation. So
It's the word taking out of the law.
right. So that's the challenge. If you send, that's out of case law. It's not anywhere in the actual statute, but it's in case law. It's in, yep.
So the actual statute itself doesn't say that, that's just from...
No, in fact, much of this that you're seeing here, the procedural standards in terms of what you have to do for remote participation, that's all verbatim from the law. But a lot of this concerning electronic communications, especially serial deliberations, collective violations, these are the unusual circumstances that were not addressed in the statute or the regulations.
Statute or the regulations don't actually talk about opinions.
Don't talk about,
Opinions through email, through a phone.
well, they talk about reports, and they say that the reports can't express an opinion. So they do very generally, but they don't talk about serial communications. They don't talk about expressions of an opinion of a member going one way without soliciting feedback themselves constituting a violation. That's from case law.
Case law has as much weight as the original statute, doesn't it? Yes.
It does.
That's what I thought.
When the new scheme was created, the new statute was adopted, the Division of Open Government was expressly given the authority to render these determinations. So these determinations have the force and effect of the regulation or the statute themselves.
Yeah. It also says may law, that's just confusing.
Yeah.
You can say it is.
Executive sessions, so the next 3 slides, I think, go to executive sessions, and I'm not going to spend a ton of time on them, but as I think you know, there are, depending upon how you count them, 9 or 10 grounds for going into executive session. Each of them is referred to as a purpose. You sometimes see them referred to by purpose numbers. Purpose 1, discuss the reputation, character, and physical condition or mental health rather than the professional competence of an individual, or to discuss discipline. Purpose 2, to construct strategy sessions in preparation for negotiations with non-union personnel or to conduct collective bargaining. Purpose 3, and this is one that is used with great frequency, to discuss strategy with respect to collective bargaining or litigation. If an open meeting law may have a detrimental effect on the bargaining or litigating position of the town. Here's another example of how, the statute says what you see, but what does that mean exactly? So a question we often get about the litigation exception is, well, does it need to be pending litigation? What if we've not been sued yet, but we know we're going to be sued? What if we're the ones who are going to sue? Can we enter into executive session before we sue? How are we supposed to have a conversation with counsel about filing a suit if we haven't filed it yet, but we can't enter into executive session to discuss it? So again, there are a series of cases that are out there, or determinations. I refer to case law, but I'm speaking generally about mostly determinations from the Division of Open Government. There are a few that have made their way to the courts, but generally these are cases that have come before the division and determinations that the division has rendered. And so they've said that when you speak of litigating position and litigation generally, you're talking about not only ongoing or pending litigation, but litigation that is threatened or demonstrably likely. That's the terminology of the cases. So if it's demonstrably likely, if it's threatened against you, or you think you're going to bring it and it's relatively clear you're going to bring it, you can go into executive session to discuss it. Purpose 4, deployment of security personnel. Obvious reasons you wouldn't want to be releasing that information in open session. Purpose 5, investigation of criminal misconduct charges or the filing of criminal complaints. Purpose 6, considering the purchase, exchange, lease, or value of real property. That one is used with some frequency too. If there's going to be a detrimental effect on the negotiating position of the town, you wouldn't want to have those discussions about what you're willing to pay for a municipal property in an open session. Purpose 6, comply with or act under the authority of any general or special law or federal grant and aid requirements. I think that was 7. 8, consider or interview applicants for employment or the appointment of a preliminary screening committee. This one's used with some frequency by boards of selectmen more than anything else. There's sort of a caveat here. You can't have a preliminary screening and then have a follow-up interview process that still relies upon the preliminary screening exemption to the open meeting law. Purpose 9, to meet or confer with a mediator. That's a new one they added in when they recodified the law, to give you the ability to meet with a mediator in the litigation context in executive session. And then purpose 10, to discuss trade secrets or other confidential, competitively sensitive, or proprietary information in the course of activities conducted by a governmental body as an energy supplier. Pretty limited exception there that really doesn't come into play too often with municipal bodies. Remember, the open meeting law applies to state agencies as well, other governmental entities, so it's not entirely or completely addressed to municipalities. I mentioned before that there are minutes requirements. Minutes must include a summary of discussions on each subject, a list of exhibits used at the meeting and decisions made, including a record of all votes. All exhibits shall become part of the official record, and there must be a list of the exhibits in the minutes, or at least reference made to them. Minutes of executive sessions are private for a while, but they must be disclosed when the purpose for which the executive session was held has been served. This is the topic of some discussion. You've got to remember that your executive sessions, although you're generally taken off television if their meeting is otherwise broadcast, those executive sessions, nevertheless, you've got meeting minutes kept. Sometimes there's audio that's kept, and all of that becomes public once the purpose for the executive session is over. So don't think you can say whatever or do whatever in executive session and it's never going to see the light of day, because it's only for so long as, you know, the litigating exception applies, and if the litigation is resolved tomorrow, those meeting minutes should be released soon thereafter. And in fact, at regular intervals, the public body has to review the minutes of executive sessions to determine if the continued non-disclosure is warranted. I've gotten questions before, not just in Lunenburg, but in other communities, about the breadth of minutes. What do minutes need to look like? How extensive do they need to be? How simplistic can they be? You know, there's no real guidance in the open meeting law. I mean, you've seen the guidance. So you've got to include a summary of discussions on each subject, list the exhibits, record votes, obviously record those who were present at the meeting, location of the meeting, the time the meeting begins and the time that it ends. Doesn't need to be a verbatim transcript, but it also has to be enough to let somebody reading the meeting minutes know what happened at the meeting. So I think that there's a happy medium there, but I appreciate that it's a difficult balance to strike. I've seen some incredibly simplistic meeting minutes that probably wouldn't meet the test, and I've seen some incredibly extensive meeting minutes that, you know, read like almost like a verbatim transcript of what was discussed, and I don't think that's necessary either, particularly where, you know, if the goal there is to give somebody in the short term, in advance of next meeting or in advance of the meeting that may occur in 2 or 3 months on the same topic, an opportunity to familiarize themselves with what occurred, you've got the benefit in Lunenburg, as a lot of communities do these days, of having video recordings or at least audio recordings. So someone who really wants to understand what happened verbatim can just watch the video. So you don't need that plus a verbatim transcript of the minutes. Minutes of open sessions have to be approved in a timely manner. That's defined as within the next 3 meetings of the public body or within 30 days, whichever is later. In most cases, the next 3 meetings will be later, but there are boards that meet on a weekly basis, in which case they'd have to do it more frequently than that. In a recent case, the AG found minutes to be deficient because they didn't identify the subject matter of comments from a member of the public, and the minutes weren't sufficiently detailed to allow a person who didn't attend the meeting to deduce the nature of the concerns raised by the speaker. So again, that's more guidance on the standard here. You can't just say Mr. Smith or Mrs. Smith spoke. Mr. Jones or Mrs. Jones spoke. The board deliberated on the topic. Vote was as follows. That's not really enough. You also don't need to discuss Mr. Jones or Mrs. Smith's, you know, verbatim testimony and every last thing they said, but it's enough to say that they got up, they spoke in opposition to the project that was before the board, they raised concerns relative to traffic and the environment. That's enough to give a general sense as to what happened.
What about posting minutes? Like after we approve them, is there a timeline where they have to actually get posted somewhere?
They don't. They just have to be released. They're a public document. Don't need to be posted.
We actually don't even have to post them.
What do you mean by post them?
Like we post them, like the clerk posts them online after.
No.
Usually there's
No,
requirement
some
for that.
communities don't post them online at all.
Okay.
Enforcement of the open meeting law. So, you know a little bit about the process because we've been involved in it on a couple of occasions, but the complaints are filed with the public body and the town clerk within 30 days of an alleged violation or within 30 days of becoming aware of an alleged violation. That's sort of a little bit of a hang up for some municipal boards that think that something's late. A good example, I had this a number of years back, is, you know, an executive session discussion occurs and it's not apparent to a complainant what occurred until those meeting minutes are released. Those meeting minutes may be released a year after the meeting occurred, as long as the complaint is brought within 30 days of the release of the minutes, and if the complainant had no other way of knowing what's being complained about prior to the release of the minutes, they could bring it within 30 days, and that would be, even though it's really a year and 30 days after when the violation occurred. But in most cases, outside of the executive session context, you've got 30 days as a complainant. The public body has to meet to review and consider the complaint. They've got 14 business days to do so. They can seek an extension if they need it from the Division of Open Government. If the public body doesn't take the necessary remedial action within 30 days of receipt of the complainant can file the copy of the complaint with the Division of Open Government. Of course, if they take the remedial action and it's deemed unsatisfactory to the complainant, or they determine that no remedial action is required based on the circumstances and they communicate that to the complainant, again, the complainant has a right to file with the Division of Open Government and seek further redress. The division will determine if the complaint warrants an investigation into the alleged open meeting law violations. That typically means that the Division of Open Government, and in my experience, and maybe there are other, I imagine I know that they get a number of complaints at the division. I suppose it's possible that some of them don't even warrant, quote, an investigation, but I can tell you that most every complaint that's been waged against the town that I've represented has resulted in some form of investigation. Sometimes it's quick, sometimes it takes much longer in more confusing circumstances, or with complaints that are multifaceted in terms of what is being complained about. Violations 1 through 10 versus a single violation. But generally the division takes its job seriously, does an investigation. They call me as municipal council, I've been involved. They call the chair of the board. Sometimes they'll call other parties who were involved in the alleged violation. Sometimes they don't. They'll review documents. They'll ask for additional documents if they need them. And that's their investigation.
Can an active board member file an open meeting law?
Absolutely.
Why? Why would they do that instead of just addressing the board?
Fair question. I think I can tell you what I've seen, and I've seen that with greater frequency than I'd like. Active board members filing complaints against their own boards, and usually it's because, in my experience, they've raised those objections to the board in the past, and they feel that those issues have not been resolved through them addressing them, and they feel they have to go a more formal route. Again, I'm just speaking from my experience. And I have seen it with some frequency. I've seen boards, board members filing complaints against other boards in the same communities. I've seen staff members filing complaints against board members. You would think that all of that could get resolved locally, and in an ideal world it would. And I, obviously advocate for that occurring. I don't think it makes any sense to, incur, time and effort and legal fees in responding to these complaints if you can try to resolve them amicably amongst yourselves, but it doesn't always work that way. So, and the law applies to everybody. It gives you the same right as a board member as anybody else in the community would have.
If they send that, if they create their own open meeting law within their own board and then send that open meeting law violation to the board, is that in itself an open meeting law violation because it's just their opinion that the open meeting law was violated?
So they're obligated to they wouldn't send it to the full board, or they shouldn't send it to the full board.
They have.
If they've sent it to the full board,
What are you talking about, Joe? Are you talking about sending out an email saying, I think this is an open meeting law violation?
The actual complaint itself.
Oh, the actual complaint
I
itself.
think the word think is an opinion.
It would be, but I'm saying if they create an actual open meeting law violation and then they themselves send it to the quorum of the board, it's still their opinion. Nothing's been determined to be a violation yet. Would
Right.
that itself be an open meeting law violation?
and I think the answer is maybe. And the reason that I'm struggling to give or hesitating to give a definitive answer is, one potential workaround that I've heard to the restriction on circulating amongst yourselves documents that might contain opinions of board members is posting that information, making it available publicly. So the whole concept of the open meeting law, one of its objectives, and the reason why you've got this restriction on opinions of any one board member being circulated, even through one-way communication to a quorum of the board, is that all that's supposed to occur in an open meeting. It's supposed to be made known and available to the public, right? Well, public documents are public documents, so there's nothing that prevents you from getting a copy of a public document that anybody else can see. So if an open meeting law complaint, and I mean an actual, not an email that says, I think there's been a complaint, here's what's occurred, I mean an actual complaint form that has been filed today with the town clerk as one is required to do, and then a copy is sent to all the board members, well, that document's a public document. So yes, it expresses the opinion of a board member, but it's been made public.
Yeah, but, well, never mind, doesn't matter.
Right.
Hopefully it doesn't happen again.
It's a borderline case. I think it would depend upon the specific circumstances, what the document said, whether it was made public prior to being circulated to the board members. Obviously, that's not the preferred way to do it. The preferred way to do it would be to do exactly what the law requires, which is file it with the public body and the town clerk. And with the public body, they mean with the chair of the public body. So these are just some of the options that the division has in terms of resolving open meeting law complaints. They can order immediate and future compliance with the open meeting law. They can require attendance at a training session authorized by the Attorney General. They can require minutes be made available if they haven't been previously made available. They can nullify action taken by the public body if it was taken in a meeting that wasn't duly noticed. They can reinstate an employee, for example, that has been terminated at a meeting that wasn't properly noticed. They can impose a fine on the public body for not more than $1,000 per intentional violation, or they can take, quote, other appropriate action.
That's a range of,
It's purposely vague. It's a range of.
there can't be additional fines.
They can impose, I would say that other appropriate action could include anything that they deem appropriate.
Why do we have those bullet points?
It's a catch-all category, as is often done by the legislature, by state agencies. They want to give themselves some degree of discretion. I will tell you that in my experience, they generally stick to the preceding 6 bullet points. I've not seen too much other appropriate action, and where I have, it's been, in addition to attendance at a training session, they've ordered review of the online trainings and a certification that you've reviewed them, things like that. The penalties tend to be progressive. So obviously you're not doing yourselves any favor if you're a repeat violator, and I don't mean a repeat recipient of complaints. You can't control how many complaints you get necessarily, as if you're not actually violating the law. But the Attorney General determining time and time again that in response to complaints there has been a violation, even if you've taken remedial action, eventually the division is going to get fed up. So usually if you've taken remedial action on the first try, they say, okay, you caught it, it was brought to your attention, you spoke to counsel, you took remedial action, that's fine, don't do it again. The second time, depending upon the circumstances, they might say that, or they might say, don't do it again and attend a training session or perform, review the online seminar. If you're doing it a third, fourth, fifth, sixth time, at some point they may get more aggressive in what they've ordered. There are a few communities in Massachusetts that have shown a tendency to repeatedly violate the open meeting law in some egregious ways, literally doing the exact same thing that they just got an opinion saying they couldn't do, like the next week, the next month. And obviously the Attorney General has not looked favorably upon that. The courts haven't looked favorably in that instance because it made it to court upon that either. So. All municipal employees will be deemed to have knowledge of the open meeting law. That's the old, ignorance of the law is no excuse. You're obligated to review it because you're obligated to receive a copy of it. Therefore, technically, any violation of the open meeting law could be considered willful because you had advanced knowledge of the law. That's what gives them the ability to say that you're willfully violating the law, even if you say, well, I didn't do it on purpose. Well, you should have read the law and familiarized yourself with it before you took the action that you took. There's a mediation process. I won't go into it in great detail. I haven't seen it used much because it requires 5 or more complaints in a 12-month period. It's a lot of complaints, but you've got these serial complainants in many communities. We have a few where we will literally receive a couple a month. And so the idea was that, these complainants are just making it their life's mission to try and wage complaints. And
What do you do about that? It's harassment. Yeah, is it harassment?
it's not harassment legally. Doesn't meet the definition of harassment. But it's a challenge. And, what do you do? What do you do about it? You resort to remediation if it occurs 5 times within 12 months. You have the ability.
So it's gonna be the same complainants?
Same complainant. That's
Okay.
correct.
So if you got a range of complaints from different people, this doesn't apply, but if it's from the same person, it does.
Right. So here's the issue. So, and I want to clarify this because I've gotten questions in some communities about, well, what if what if he's to blame, as they point to their, their partner, another member of their board or public body? What if he's the one that's constantly causing the violations? The mediation process isn't mediation amongst the board to try to fix what's going wrong. You're expected to know the law and to fix it or to face the consequences. And I think that if the Attorney General sees that it's a particular member that's causing the problems time and time again, they'll be on notice of that. They'll take note and they'll fashion a remedy accordingly. The idea here is that when you've got a complainant that is really holding up business because you are meeting after meeting having to address these open meeting law complaints, the mediation occurs between the board and the complainant to get the complainant to stop making these complaints. What can we do to try to rectify it? So the public body can request mediation with a complainant if there's 5 or more complaints within 12 months. The mediation is rejected by the complainant. The Attorney General can refuse to review further complaints received from that complainant.
Individuals, households, but like individual people.
Individuals. That's how the complainant is defined. Another new provision deals with certification. So new members appointed or elected have to be provided with copies of the open meeting law violations that have been received by the particular body to which they've been appointed or elected over the past 5 years. And the goal here, of course, is to prevent repeat violations. And again, I cite to those instances of communities, certain boards in communities where there have been violation after violation after violation, and by the same public bodies. And new members need to be on notice of what's gone wrong, so they can't later claim, "Oh, we didn't know," or "We're new members of that board." AG has authority to issue advisory opinions, as I mentioned before.
Those are just opinions, though, correct? So we've had instances in the past where they've asked the AG and they said, this is just an opinion, not a ruling, and then we got the email back, oh, the AG said you violated it, here you go, or something like that. So that is just an opinion, that's not an actual statement of a violation.
Right, so I want to distinguish between opinions and determinations. And I should have been clear from the start of the presentation in choosing my terminology, because I also referred to case law. What's referenced here by advisory opinions is exactly what you just described. Non-binding advisory opinions that generally won't be put in writing, although sometimes they are, to give advice in advance as to whether you can do X or do Y or do Z. It's possible that you may get that advice and then they may go back on that advice, either because of intervening determinations that have been issued in writing in specific cases, because of case law that has been decided in the interim, or because they've given it further thought, they didn't have all the facts before them. They're careful in caveating the advice they give, because typically when you pick up the phone and you call or you send them an email, you're not giving them every last fact. And when they review it all and they do their investigation, if there's later a complaint, they may learn things that you didn't disclose to them on the telephone or in your email. So these are just advisory. The determinations are what they issue after there's been a complaint. That complaint is not resolved to the satisfaction of the complainant. They then appeal it further to the Attorney General. There's an investigation. What results is a determination, and that's what I refer to when I say case law. I'm in the body of written opinions. They're referred to by number, the year, 2018 dash, and then whatever number opinion it is for that year. And there's usually, a couple hundred of them in a year. And they've been ongoing for a number of years now. So you can go right onto the database, the online database, and you can search by word, by phrase, by topic, and you can review all these decisions. They're all PDFs that are uploaded to the division's website. So the idea behind an advisory opinion is that an action taken by a public body in good faith reliance on an advisory opinion will not constitute a quote-unquote intentional violation. You saw that definition early on in the presentation. Provided that the circumstances are not materially different from those that were in the advisory opinion. Again, they're caveating it because they want to be sure that you're disclosing all the information. And then here's the note at the bottom. They relocated it within the open meeting law when they recodified it, still providing you with some protection, but it's now no longer in the definition, so it's not a per se defense. But if you rely upon the advice of counsel, you may assert it as a defense to a finding of an intentional violation, showing again that you did your due diligence and you asked the question in advance. That's what we've got.
Just to follow up on the discussion before, if there's someone who is frustrated, and sort of some of the examples you had would sound like, someone who's frustrated with a commission, doesn't feel they're getting their attention through whatever direct methods, clearly they can go this route. That's clear. But what guidance would you give for an intermediate level, for someone who really, just wants to solve what they perceive as a problem and doesn't want the town spending a lot of time and energy and legal fees? What other steps might they take in our town?
To try and resolve their grievances with a particular board?
Right.
There are a few ways to go about it, and some are perceived to be more aggressive than others. Obviously, the most simplistic approach is to come to the commission, ask in advance to get onto an agenda, or arguably you could address it during public comment, and to raise the issue and to engage in that dialogue. That requires, and I'm not speaking about any particular situation, and I don't know even what your practice is other than the few meetings I've attended or watched, but that requires a board or commission or committee or public body that is amenable to allowing that to be said in a public comment session and to engaging in a dialogue. I mean, I've said to many boards that I represent, you have no obligation to respond to public comments, and I almost suggest that you hear the member of the public out and then move on to the next comment. It's not meant to be a dialogue. It's not really an agenda item. So hear them out and then move on. So that really doesn't give you the opportunity for dialogue unless they get onto the agenda in advance, and that needs to mean that means that the chair would need to allow them to get onto the agenda in advance. So that's sort of the best approach. Another approach is to go to, again, and this could be perceived as too aggressive, but go to a particular board or commission or committee's appointing authority if it's an appointed board. I've seen that done with some frequency, go to the appointing authority. If there's no appointing authority because it's an elected board or an elected commission, sometimes they've got you referred to it as a liaison, one of you did, a staff member. In your case, Barb would be your staff member and say, hey, I've got some issues. Can I try to work these out? Can I have a meeting with you if you have the authority to meet with me? Or can I have a meeting with the chair or a meeting with a couple of members of the board or commission or committee, as opposed to meeting with all of them to discuss some of the issues that I have? So you're not,
Does that
again,
need to be posted then?
not if it's a couple members, it's not a quorum.
As long as it's not a quorum.
Right, can't be a quorum. If it's but the idea there is, on the one hand, it might be perceived as aggressive because you're not coming to a public meeting and you're sort of making an end run around the board. But in some respects, you're not, because you're then having that conversation in private with one or two representatives, and it's not in a public meeting. So maybe that's a better place to make your grievances known. So I've seen both of those things done. I've got to say, not with great frequency. Unfortunately, my experience anyway is that complainants rely upon this process. And that goes for complainants that are outside complainants, and that goes for inside complainants, members of the boards that they're filing complaints about, members of municipal government filing complaints against other members of that same municipal government. It's just what I've seen. I've seen there's also the ability within the law to go directly to court. So you don't have to avail yourself of the process that we outlined here. You can simply bring an action by statute and commence litigation against the town for violating the open meeting law. So that's problematic too. I've seen that done in a few instances, and that's worse than this process because the costs, increase tremendously, as you might imagine, with any sort of litigation.
Absolutely. Okay, thank you. So we've confirmed again that two members can have a discussion about matters between the board without violating open meeting laws, at whatever risk they choose to take to do that. But some members have been accused, have called that doing business. Is doing business outside of an open meeting, have any basis in this law, or is that just something made up? And what does that mean, doing business?
So I'm gonna speak to a particular instance here because it's all public knowledge, and I think it's a fair example. So your commission received a complaint from a former member of your commission a few months back, and it raised an issue, and I'm not speaking to the truth of the matter. We addressed that already substantively, but it raised an issue, and for argument's sake, let's assume it was true. It raised an issue that there was a communication on behalf of the commission that was not supposed to be a communication on behalf of the commission. And I understand that, I think the determination we reached is that was not the case, in fact. But had that been the case, would that have been an open meeting law violation? In our opinion, my opinion, and hence the response from the commission, you might recall, was, first of all, that's not what occurred, was our position. But even had it occurred, it's not an open meeting law violation. And in fact, my recommendation was all the more reason to do something like create a communications policy, which I know is on your agenda tonight, because that's more of a question of communication, the board doing business, who's authorized to speak for the commission, what authority need be given to that individual to speak on behalf of the commission. How can the commission conduct business outside of an open meeting? Because the day-to-day business can't be conducted through an open meeting, right? So how does that get done? Does it get done through the chair? Does it get done through an authorized member on a case-by-case basis? Does it get done through your business manager? Those are decisions that need to be made. Some of that is provided for by charter, because we have a business manager, and the business manager has certain duties, and the business manager is appointed by the town manager. Some of that exists. There's a phrase day-to-day operations that exists in the charter. So some of that's provided for, but filling in the holes with the communications policy makes some sense, because I don't think it's something that's addressed by the open meeting law. The open meeting law doesn't address who can speak for or on behalf of a public body. The law in Massachusetts, outside of the open meeting law context, is that multi-member bodies act through a vote of a majority of their quorum, unless there is a statute that provides otherwise. So a quorum of the body can meet, can transact business, and a majority of the quorum is sufficient to take action on behalf of that particular public body, unless a statute provides otherwise. That's the general rule. So no one member is vested with any authority to speak on behalf of a public body unless that public body has voted specifically or given general authorization for that to occur.
So the term or complaint of doing business outside of open meeting isn't really contained in the open meeting law?
No. Not as we've just described it.
Right.
I mean, not as we've just described it. I think you could take that phrase, doing business outside of an open meeting, different ways. And I think it could be used in a way to suggest that that's an open meeting law violation. You can't do, if you had three members that were meeting together and trying to flesh some things out, three members outside of an open meeting, that could be considered doing business amongst themselves, and that would be an open meeting law violation.
Right.
But, one member or two members, less than a quorum, trying to get stuff done, communicating with consultants if they were all authorized to do so, that's permissible. But there needs to be the authorization, because no member can say, I'm representing the commission on this, I'm giving you authority to do X or Y or Z, unless they've gotten that authorization from a majority vote of a quorum of the body.
Right. Okay, thank you.
Sure.
Moving forward. Tips?
Don't send emails.
So, in part, yes. In part, my recommendation is electronic communication is a trap for the unwary, unfortunately. It's the way things have gone in recent years. So much occurs now online through email communication. And as I mentioned before, it's not just email communication, it's other forms of social media. And that's become problematic in so many ways for public officials, and that includes, volunteer members of public bodies. I think that some of it can be done if it's simplistic and non-substantive. I've got no issue with trying to coordinate dates for meetings via email. That makes a whole lot more sense than trying to pick up the phone and get everybody on a conference call. I've certainly got no issue. And again, it's not something to shake a stick at. I think that sending substantial information received from residents, from your consultants, from an applicant's consultants, from the applicant itself, circulating that in advance of a meeting can go a long way. That's going to be far more substantive, typically, for many public bodies than things that are generated amongst yourselves, especially on larger projects. So those things should all go out in advance. I would much prefer you to have that 100-page traffic study in advance as opposed to having to flip through it all at the beginning of the meeting. So I'm not saying don't do any business via email. Some of that can occur, but resist the urge to hit reply all. Frankly, resist the urge to hit reply and to share opinions. Do that in an open meeting. That's what the meeting's for. Share opinions in an open meeting. Share comments, even if you think they may not be opinions, in an open meeting. That's the safest way to do it. And that goes not only for all of you, but it goes for staff too. That when your business manager gets an email from one member that says, here's what I'd like to get done at the next meeting. Here are my thoughts about this, and here are my thoughts about that. That should be discussed at the next meeting. But reports and other documents from third parties, scheduling, the agenda itself, I've got no issue with those items going out in advance.
Adam, I have a question. I liked the section on remote participation. You know, I often travel, and if there was a meeting that I really felt strongly about the topics being discussed, that would be a way I could still participate in the meeting when I was out of the country or something, right?
Sure.
Yes. Is there any other way that is appropriate for me sharing my opinions on topics on the agenda? Let's say I'm going to be away, I am going to be away in November. Is there any other appropriate way for me to be sharing my opinion on topics that will be discussed at the meeting when I'm not there, other than remote participation?
Yes, and in fact, I think, Carl, that you might have done that just recently. I watched portions of a meeting where there was a summary of comments on certain topics on the agenda that was provided in advance to Barb. Again, the caution there is you've got to be careful that that doesn't get circulated to members in advance of the meeting. But if that's something that's provided to a non-member and is brought to the meeting and then is read aloud either on a topic-by-topic basis or read aloud at the beginning or the end of the meeting, I've got no issue with that because it's all being presented in an open meeting. That's okay.
So we would just send it to Barb, and that's where it would stop. We wouldn't send it to additional members of the committee. We'd just send it to Barb, and then she would bring it to the meeting for the chair.
That's the safest approach, yes.
Yeah, but even that could be, but every email is public record, right?
Email is a public record, that's correct.
Public record can be requested.
It can be requested, yes, for sure. I mean, if there was an effort by another member of the board to create an open meeting law violation, they could request the public record that they knew existed and then read it.
Anybody could do it and then just be like, hey, look at that.
Right.
There's always that.
Well, it's always going to be read at the meeting, which is open.
No, I
So-
mean, like, if you sent it to Barb and then for some reason someone's like, hey, just give me an email that Joan sent out and they saw your opinions, I mean, it's just the whole thing is weird.
Well, but you would, but I would assume if I sent it to Barb, she would say, Joan can't be here, but this is how she feels, and she would
No, that's-
give
yeah.
me author.
I think you're missing what I'm saying.
Probably I am.
I think you are.
I am.
It's just my
Just
opinion.
reply, I'm out of the country, I'll see you next meeting.
Yeah, that's,
Yeah, in front of the meeting.
Right.
Anybody else got anything for Adam? Appreciate you coming in.
Okay.
Thank you, Adam.
Thank you.
Thank you, Adam.
Hopefully we
Sure.
don't do this too much.
No, it's okay. I'm going to stick around to hear your piece on the communications policy, and if you've got questions, let me
Stay
know.
right there if
Oh,
you want.
good.
All right. Moving into communications plan workshop discussions.
Do we want to invite Heather?
Yeah, we're gonna invite Heather and Jack to come on over here too.
I do, thank you. Not better yet. I got bit by a bee. And it's just, my whole hand is swollen up. I don't think so. But
Maybe now.
maybe that hand is. It's just fat, yeah, it just keeps keeping bigger too.
I got it. No, I'll move it. You can sit right there, and then you want to go? Okay.
You're watching over you,
Yeah, I
making
know,
sure you
see,
didn't pass
I
it.
didn't think about it.
All right, the very long overdue communications plan workshop discussion. So, let me just preface it by that's exactly what this is going to be. It's going to be a discussion. I don't want any crazy past history, well, you said this, you said that, argument type stuff going on. It's just going to be to how we move forward with communication, whether it be email or anything like that. What is this?
There we go.
Oh, okay. Is this based off of other
This is-
communication policies?
Holy crap. I mean, this is a good example. I think it would have been okay to distribute this in advance. I mean, it's a,
Yeah, we can talk and then we can probably go through all this stuff. But thank you for putting this together. So do you get, is there other, I mean, I haven't looked into other communication policies in town, so I assume there are other boards that have communication policies specific to their board, and maybe that's kind of what you leverage to create this?
The selectmen have policy is more succinct than this one. But this one is based on items that came up in the discussion of previous supervision meetings.
let's just start off by getting, if anybody already, I assume people have already taken notes and kind of have ideas of what they want to talk about. What I have here is bullet points that Bob put together and I looked over, and Bob, I assume the stuff you emailed me is also on here? You talked a little bit about bullet points of things.
Yeah.
On the working agenda.
Right.
Did you already summarize those?
Yes.
Okay. So.
And those are my opinions,
Yes,
just.
no, I know,
Okay.
I wrote my own down too.
All right.
Just some of the suggestions, a liaison selected from commission to work with Jack. Real quick, let's get into that. So, before what we used to do was Barb would kind of talk to Jack, or all of us would bombard Jack with emails. So, is it a good idea to have a liaison from the commission to work with Jack? It takes Barb kind of out of the loop a little bit, so she's not constantly bombarding her own boss with things that we're trying to get done. I think it's a good idea, and I'm wondering what other people think.
I think it's a good idea, and I think it would provide continuity.
I think it's a good idea because it prevents multiple people from speaking or interrupting the DPW work with the same topic. If we discuss it as a group, and then we say, okay, liaison, find out for us, I think, or we have some sort of communication pattern between meetings. I know that I emailed you that I had a question for Jack before a meeting, because I believe we voted at one meeting that Joe was going to be the liaison for the
I think we
DPW.
voted for an official liaison type thing. We talked about going through B for the most part, but it was always kind of tabled for a discussion like this. So I don't think we actually officially voted.
I think we did, but I can look it up in the
Yeah,
minutes,
you can
but
look it up. I'm
I
not sure if we did or didn't.
think we did. But I think that one person funnels everything down, and instead of getting bombardment, because if I have a question and you have a question, and we both tell John we have the question, and he's the liaison, well, then he can just ask one question, as opposed to...
Thoughts?
No, I like it. It's a good idea.
Jack? What do you
Yes,
think? Good?
that's fine. I mean, this is your policy to make. I appreciate that
If
courtesy
it affects
that
you,
you,
get your opinion too.
clearly the policy-making commission. Carl?
You like it?
Yeah, no, I think it's a great idea.
All right.
And
so-
I agree, we had discussed this,
Yeah, I think we
and you were it.
Yeah, so we want to keep it be the chair, not me
I think-
specifically, but just a position of chair.
I would suggest the chair, because that's the person who's most knowledgeable and involved in everything.
Yeah, did you happen to have that in here? We can add it.
The only thing, I have a little addition to that. I think that that would be great for the chair to be the liaison. But I would appreciate it, and it might help out if we could get an email, quick email back. In other words, if one of us calls you or emails you and says, we have this question for DPW, and you're going to ask it, if you could just let us know. Just text, thumbs up, got it, or just some feedback that it was received, so we're not sure,
Yeah, I think I left you hanging that time.
Yeah,
I
you
did
kinda-
forward it to
yeah.
Jack, but I don't think I told you I did.
Yeah, and just so you know the status of what has happened.
Yep, we can have that in there. Okay.
I also think it's probably a good idea to be the chair because the chair has more communication with the business manager than the rest of us,
Right.
so.
So we like the liaison to Jack, we'll make it chair. And then chair to reply back. That it was either done or not. Next thing I have here is if a member wants their opinions presented at the meeting, they need to check with the chairman before,
Yeah, and this came out just tonight,
Yeah,
and
okay.
I can see not doing that, but what I would only just ask, if you want your opinion shared at a meeting, that it's actually provided in a succinct format, not just, tell them that I need, a piece of paper, because there's a lot going on, and sometimes it gets lost or misinterpreted. And just if you want an opinion shared, that there's a handout that I can give at the beginning of the meeting.
This isn't, the member isn't going to be at the,
Yeah,
Right.
Barbara's not gonna be there, so it should
Yeah.
go to Barb, not to the chair.
Right.
Should go to Barb, and it should be some sort of,
Yeah, I think
maybe a formal form.
it needs to be written.
something-
It should be
something,
written.
Written communication, that Barb can either print out and bring in and just kind of distribute.
Well, yeah.
And I-
I would say it should be read at the meeting if a member isn't there and they're providing
Yeah, right.
opinions.
So,
Because otherwise, everybody reads it, and it's not really public.
It has to be read aloud at the meeting.
Right.
And the member who wrote it name should be attached, they should say,
Yes,
Joan Pease can't be here, but she would like her opinion known, and here's her opinion.
right. Yeah,
Yeah.
that's my feeling.
So this is really just to clear up that people aren't just calling Barb and say, hey, tell them this.
Right.
That should be a formal, like a written, something
Right.
written that they do.
And I will hand it out, but I will ask everybody's assistance in remembering, like Joan did the other night. Just to remember that at every time the
Topic.
subject changed, that you read
Right.
aloud that remote opinion.
Are you taking points from the floor, Joe, or are you just, are you taking points from us, or are you just going down your list?
These are just my list, and then we'll
Okay,
go
okay.
through everyone else's list.
Okay.
Well, it's really me and Barb. Barb, I don't know what this next one actually is. Handouts should be provided of commissioner or DPW input if unable.
That's the same. That's what I just said. It's just something succinct that,
All right, so contractors and consultants communications, I think this is probably on everybody's list to talk about who can and who can't talk to contractors and consultants. I know we've talked about this before, and we kind of put the stop to anybody reaching out to consultants and contractors, and we kind of just funneled it through to Jack to talk to contractors and consultants. What's everyone's opinion?
I disagree with that.
Well,
Well, I think it's,
It wasn't a
a-
statement, I was asking what everyone else's opinion was.
well, that was my
What do you
opinion,
want it
was
to
I
be?
disagreed. Well, I think I think one, there's already a definition of who is supposed to be the conduit to consultants and contractors and everyone as a default, which is the business manager, and that's in her job description. But I think also the other criteria should be what the subject is. If it's a subject of engineering that is under the control of the sewer commission, then I think it should be decided by the sewer commission. If it's a day-to-day operation and it's an ongoing thing and it's a contract that's under the control of DPW, then the DPW would be the default. But the highest level default in the job description is actually Barb.
right. And however, it does happen that Jack's already working with a contractor or consultant, so I'm stepping on his feet if I am tasked to contact a consultant. So I would still always have to defer to Jack or my liaison to say, this is the situation.
Well, unless it's an issue that's under the control of the sewer commission, then it wouldn't default to Jack, is my feeling.
Well, like, I wanted to check the references for the irrigation meters from the demonstration we had. He sent us a list of recommendations. And I thought about doing that after the meeting, but I didn't do it until the next meeting. Joe, you weren't there, but I asked the rest of the sewer commission at the last meeting, is it okay with you if I check these references?
I think that's probably what
So-
should be in the policy.
So that's what I'm saying. Really, I wouldn't, even though I was curious ahead of time and I really wanted to get going on that, I didn't. I waited for the meeting. I asked the commission's pleasure, and everyone who was present said they thought that was fine if I contacted those references for the commission. So I just think we need to make sure that we don't act alone, that we act with,
That's exactly like the point of the bullet point, is to make sure people aren't just reaching out without talking to anybody
Right.
first. Because then it appears like someone's working on behalf of the commission and they might not be.
right.
So that was the point of that whole thing. So in this policy, we want to make sure that it clearly states that before anyone on the commission reaches out to a contractor or a consultant or somebody, third-party type thing, that the commission's okay with it. And at that time, we'll decide how it's going to be done.
Right.
Whether it's,
Well, why
June.
would we reach out when Jack does the day-to-day already?
well, it might not be day-to-day stuff. Like, we would reach out for like engineering type reports and things like that. So, and at the time, when it's brought to the commission, it might be that the commission says, no, let's let Jack handle that.
Right.
It could be one of those things, too.
The discussion might go that way.
So I think the only thing that should be in the policy is that it comes here for a discussion, and at that discussion, we'll decide who's going to say what to who. We'll word it better than that. But just so we all agree that, yeah, we want John to go talk to this person, or Joan to talk to this person, or something like that. So that's what the policy should say.
Yeah, I agree.
Everybody good with that?
Yep.
Yep. So we don't do site visits or anything. That's,
We wouldn't just show up
yeah.
to anything.
It's discussed. We've had issues like perking, and I think Carl
Yeah,
and
we
you went
That's
on
actually a good
site.
thing to bring
Yeah.
up too, that we shouldn't just
Oh.
show up to anything without anybody knowing that we were showing up. Like, I've driven by like sewer work and stuff like that and seen people, I wouldn't stop.
No, you wouldn't
Say,
stop,
Hi, I'm
no.
from the sewer commission or anything like that. So maybe we should put a line in there
But we have had times when we've been told ahead,
Right.
they're going to be pumping this grease trap at such and such a time on such and such a day, but the whole commission has discussed anyone who wants to attend can.
Right. Yeah, we
It's
always
not
delegate
just
it to
one of us
somebody.
stopping somewhere and talking to
Right.
someone. Right.
So that's kind of falls.
Well, can we clarify that simply because I remember when during the manhole inspections, I drove by and they were, filming one of the manholes, doing what they do. I just stopped out of curiosity and asked the process they were going through. Are we saying that I can't do that?
Did you identify yourself as
Absolutely.
representing this?
Not representing the sewer commission, no. But what you're saying is, I really shouldn't do that.
That's what I'm saying. If you
Yeah.
disagree with us, we come up with a better idea.
But see, I don't think you should do that. I really don't. I think that, if they're gonna be repairing manholes that we know about and we talk about it and someone wants to go, and we all know they're gonna go, or everyone has the opportunity to go, then I think that's great. But we're not an inspecting body. We're a policy body.
If you're just
I
curious,
think
you
it's
could've brought
better
it
if we
together.
all discuss it and then,
I agree with John. I think that's getting a little restrictive, that you can't stop. I mean, you can't claim to represent the sewer commission. Clearly, you can't give direction, you can't, but to be able to stop and ask a question, I don't understand why we would restrict people's, rights to do that. I mean, a resident can do that. If they see someone, at the pump station, a resident can stop and ask, who you are, what you're doing. If you're driving by and you forgot that they're cleaning the Graham Street meter that day, and you drive by and go, oh, I forgot all about it, and stop by, and I don't see any problem. I call it, getting good information in the field and boots on the ground. I mean, again, you're not giving direction. You're not, redirecting people. You're not representing the commission. You're trying to be engaged and involved and learn what's going on and be aware.
Joe Heather wants to say something.
I think that could be possibly misconstrued as giving direction in the field. I think something of that nature would be best to be directed to the business manager and she look into it. But there's a concern about conflict of interest.
I don't know why you say that would be construed as giving direction if you stop by and say, geez,
Well, I think it could
What-
interfere
what
with work
came out of the-
progress. I think it could interfere with work progress. They're there to do a job, and either they have been told by the DPW to do the job, or they have been told by the sewer commission, who then instructed the DPW they wanted something done. Workers don't randomly go out to work and pick something in the morning that they just want to do.
I didn't imply
There's
that.
a plan, okay, there's a plan. And I think people stopping and interfering with the progress of their work, I'm not sure it's even within the legitimate authority and scope of the sewer commission to do that. I don't know, maybe that's a question for Adam.
but you say interfering with the work. I'm not talking about interfering with the work.
Well, if they stop to talk to you, you're interfering with their work. And if all of us did that on a random basis, you could possibly have 2 or 3 people stopping to talk to you about your work at different times during the day. Adam, what do you think on that?
So, I think there's a couple of things here. So the day-to-day operations are vested in the business manager. I think that the charter is clear in that respect. So the question really becomes, what's the purpose of the visit? And is there interference? Is there direction being given? And I can appreciate both perspectives. In some respects, it could be perceived that anybody who happens, whether they've got their sewer commission hat on or not, to be a sewer commissioner by virtue of stopping by is sending a message, explicit or implicit, from the sewer commission. I get that. I can understand how it could be perceived as interfering with their work. As you say, if everybody were to stop by and do that, that would be an interference. On the flip side, I can also appreciate the reality that as a sewer commissioner, it's generally a matter that's within your purview. It's not the day-to-day in the sense that that's something that Bob is responsible for. But it is something that you probably discussed at a past meeting, you may be discussing in a future meeting, and inquiring without giving direction, inquiring without stating that you're representing the commission or giving direction from the commission, one could say that it does no harm. So I appreciate both perspectives here. I think the question just has to be, what's more important? Is there so severe concern for the message that's being sent and how it could be perceived that you want to establish a policy that there shouldn't be anything, that there should be no sort of casual contact or communications of any nature with individuals who are performing work that would generally be overseen by Barb or in some respects overseen by Jack? Or do you believe that there's some benefit to having boots on the ground? It's a balance.
I mean, we just talked about the policy, just come to the meeting to talk to third party. I think, well, that should not just be phone calls and emails, it's also just stopping by and seeing what the third party's doing. It's my
Yeah,
opinion.
I agree. And we have a liaison to go to the DPW
Right.
so that we're all not doing it, so that it's kind of organized and not just,
Like, I wouldn't care if you did it, if we just said, hey, if we were talking about the manhole thing, and you're like, hey, I want to stop by and see it. I'll try not to get in the way, but I'm going to check it out. I think
or you might say, does anybody else want to go by and look at it with me? I'm going to go on Monday at 5, or Monday at 3, and then anybody, just like we do with the grease traps, we give a time, we give a date, and we go, if we want.
Yeah, and I understand, and I can appreciate it's very restrictive.
It's extremely restrictive, and I guess I don't see that what's driving the need for it. I mean, has there been a problem related to this? I mean, we used to call it walking, management by walking around, I mean.
But are we a
You're-
management body? That's the whole,
Yes, we are.
we're a management body. We're
That's-
a policy body, are we a management body? That's an important question.
Yeah, we don't have time to get
Adam?
into the
Yeah, that's
charter,
not-
though.
that's not- Yeah, we're not going to get into that right now. Well, my opinion is that I don't see a reason why it can't be brought to the meeting beforehand. We are the one who kind of set all this stuff up.
Right.
Who hires the contractors?
We decide the scope of work, and then Jack goes out and does the bidding and things like that.
That's a choice, that's not the policy. I mean, our engineering work, we have our own budget, we hire the engineers, we get,
Yeah, but we're talking about boots on the ground stuff, that's not engineering work. We're talking specifically to this, what we're talking about right now is if you can just stop by and watch
well,
somebody doing something else.
our meters, the flow assessment, that's our contract to calibrate the meters. It's not a
If they're gonna-
day-to-day.
But when,
That one you can schedule, but you may forget to talk about it at the meeting. But not everything you can schedule.
I think it's, I can see how I can respect that it's restricted. The problem is that we've had issues in the past, and I don't want to bring up all the bad stuff and get into discussions about whatever is people's opinions of what should and shouldn't have happened. Personally, I just don't see why we can't bring it to a meeting and say, hey, we're scheduling this, or the pump station's going to be done here. I want to take a look at it, and all of us can say, yeah, go ahead, but I don't think anyone's going to say no to you.
No, but somebody might say, I want to join you.
Yeah, or maybe somebody else wanted to check it out, exactly. And I understand that it can restrict, because maybe you would just drive by someday and see it and just stop by. In that case, I would say, if I were you, I wouldn't say anything about being on the sewer commission. I would just say, hey, my name's Carl. And they might tell you to get lost, because I really don't think any resident can just show up to a work site and just pop their head in.
It happens in your front yard, yeah, maybe. It's like, what's going on?
Well, we
Yeah.
can ask Jack that question.
Yeah, I mean, Jack, if someone's doing road work and some resident just wants to see it, wouldn't you tell them, hey, beat it, it's a safety issue or something? I mean, I don't know how often you can just walk up.
If it's in the road, it's not a safe situation.
Right.
You shouldn't just be wandering in the road without, the proper safety equipment. And so anything curb to curb in traffic, we have police. If you just happen to drive by and you see a work zone in progress, probably not a place you want to stop and park and wander into. There's a dangerous factor, a safety factor, I should say. But if there's a particular interest in seeing an operation, and it's in the roadway, for instance, let's say the checking of the meter on Route 2A in Fitchburg-Leominster line, that's certainly not where you want a lot of people. You don't want a lot of bodies there. You don't want them on Summer Street as well. If it was of special importance, then I think that could be set up with no problem.
Ahead of time.
Yeah, so we could set it up. I mean, we're not voting on anything right now, but I think that should go into the the policy. Obviously, we're gonna have to type something up, but
Do we ever go to the pump stations as like a, just to
I haven't.
see how they work?
I don't know, have you ever done it? I know you guys
Yes.
said pump
Like a,
and
like a
things
field
that.
trip of
Yes,
some
we
sort?
have.
Yeah,
It's-
there was
It's valuable information.
Previous, some previous members wanted to set up a, as you said, a field trip. That's certainly acceptable.
Especially where Ryan is new. I mean, I
Be
think we've
interested in
offered that to,
Good, we can set that up. Excuse me, Barb?
we've offered that to other new members just to get an idea of what
Yeah.
we're talking
Yeah.
about. So that would be, I think small water would be,
If
or
you're
you guys.
interested, we can take you on the tour.
Okay, we'll move on from that right now. Do we want to, in this communication policy, define roles and responsibilities at all in our communication policy? I think it's kind of, where is it defined right
It's
now?
the charter. I mean, that's the,
That's kind of like the gray area. There isn't really a roles and responsibilities for each person specifically designed in our charter.
right,
But is the
Or-
communication
or
policy
well-defined.
the place to do it? What's everyone's opinion on that?
No.
Well, the only thing is, it's a role or responsibility who contacts a vendor. So we've kind of done that. It's not the individual members, it's the commission as a whole. So we've kind of touched on some of that stuff already. One of the things that I wanted to touch on tonight was communications through Barb, to Barb, through Barb, between meetings. That's something that I think we should talk about. How many communications do you know, I mean, I rarely, I mean, maybe, I don't know, a couple times a year, 3 or 4 times a year, maybe you have to call Barb between a meeting with a question.
So I do have something similar to that.
Okay, good.
Barb
I'll let
brought-
you go then.
Barb brought up that people sometimes just email her agenda inputs. And that's, I think, a brunt of a lot of the emails that you might get throughout the week from commissioners, is people want to see certain things on agendas. Barb's suggestion was to go through the chair before it go to her.
Well, we have
the end of the day, I
we have
kinda
a thing
chopped up
on the
anyway.
agenda at every meeting that says future agenda items.
I know, but some people think of, I mean, you get 2 weeks in between that.
Then
might
I
bring
think they
something
should
up.
go to the chair.
That's what Barb suggested.
I think they should go to the chair. I don't think that we should be putting Barb in that position. And then, Joe, it's your decision-making on what gets on the agenda anyway. Barb helps you with questions and stuff, but you're the one who decides. So I think requests for agenda items should go directly to the chair.
Anybody disagree with anything like that?
I agree with that. But, like, there are a couple times when I go in and ask Barb for clarification on things, and is that something I'm going to have to stop doing?
No, I would say you can continue
Okay.
doing that. I mean, we don't want it to be super duper, like, crazy where no one can even do anything. Which I don't know if that's the direction we're headed here, but we'll see. It's okay, we all agree that agenda items shouldn't be sent to Barb directly in between meetings, they can come through the chair. Do I have to keep writing or is everybody typing? It's, you guys are good, okay.
Barbara's
I know we have like
typing,
5 or
Heather's
6
typing.
different people typing. I'm gonna
minutes,
stop writing things, then we'll stop writing things
Town
down.
manager.
All right.
I think you're covered.
Yeah, I think so. Plus, I can barely read this anyway. All right, let's see. So the next bullet point that Barb has here, chair or selected member of the commission acting on behalf of the commission within specific parameters by vote of the commission.
similar to what Joan was saying, just like her going to the references for the irrigation meters, and
to the
Carl's going to Wright Pierce, I think was for Tilton Ave, just that it is an agreement at a meeting of the full board that Joan is tasked with that, that's all.
Here that states if we're really going to go have send somebody, then we vote on it.
Right,
Right.
Yeah, we say, we vote, say, yep, Carl has
Right.
the right to go do that.
and it's clear in
If we've done it in the past,
parameters,
then
like,
it's never been a policy.
right, clear parameters.
Okay, everybody good?
Yes.
Yep.
This next one should be self-explanatory by now. No emails sent.
Just on a general thing on that, because, a big part of anything is learning, and learning's important to making decisions. I assume when we talk about going to contractors, we're talking about going to active contractors.
Yeah, I would think so. Not like, you mean
Yeah.
like trying to scope out new suppliers or something? like
Yeah,
that?
yeah.
I mean,
Or
that's a thing
go
we
learn something else. I mean, there are
We're just talking
people.
about it, right?
Well, why don't we talk about it as a commission, and then if you want to do that, you bring it to the commission, and you say, I'd like to go and do this, I want to learn more about this, I have some questions,
Why-
and we'll talk about it, and then, so we act as a team, so we're not having anybody...
I think it's extremely restrictive to tell people they can't go make a contact with an engineering firm to learn something about sewers.
Yeah, I don't think that's a problem.
Yeah.
You go into
I-
networking or something like
Yeah.
that, and you learn something.
Yeah. I mean, I go to
If you
the
really want
AMA,
to-
and there's
I mean, it's not like-
contractors all over
Are
the
you
place.
identifying yourself as a member of the sewer
But he
commission
can.
when you do
I
that?
would think that you can there, because it's not like he's gonna go out there and guarantee anyone business. He's just gonna go out there and meet people. Why not? It's like being on LinkedIn, you know?
What do you think, Heather?
I don't know.
Okay.
All the research.
I don't even know, I mean,
We'll go with that.
yeah, if Carl just knows somebody who works at like some sewer type firm or something like that, and he talks to them.
Right.
I don't see how that could be a problem. It's not like he's gonna give them business or something.
I don't think so. I just want to make it clear that, you know, I think what we've been talking about when we say bring it to the commission is
current contractors.
current contractors,
Okay.
you know,
Right.
we don't want to mucking around in that without everybody knowing.
Right.
It's like going to a trade show.
You go to a
Right,
trade
yeah,
show,
yeah,
you
yeah.
talk to
Go to
people and you
trade
learn
shows.
stuff, and,
Right.
you know, you
Yeah.
talk to them. Okay, I just want to be clear. It seemed trivial to me, but I just,
Yeah, it's fine, yeah. That's
Wanna be
good-
clear.
Good point, though.
Can be defined.
So the next one we had here is a no email sent to a quorum from a commissioner other than discussion of scheduling meeting, distribution of agendas, or distribution of third-party reports, docs to be discussed at a meeting. Heather, I have to assume you have that in here somewhere.
It's open meeting.
Yeah, it's right in the whole,
Basically.
it's right in the purpose of the whole thing.
Right.
So we all agree to that, right? We agree that we're not going to violate the open meeting law.
that we don't, yeah, right.
Thank you, I'm glad. That should be unanimous.
So we can read some of these, and then,
Yeah, so we can go through this too.
not tonight, but.
Yeah,
Yeah, not
because
tonight,
really
please.
is just to kind of jot down ideas of what we want in the policy, and then I assume people are going to, Heather, can you send this as a Word doc to all of us at the end of the night too, so if they want to hack it up and kind of edit?
As long as you don't make comments and pass them out to everyone before the next meeting.
No notes in
And
the
then the
column.
next bullet point, obviously, no opinions via emails on here.
Yeah,
Let me just make sure I covered all this stuff. So we did liaison Jack, email correspondence, consultants and contractors. Do we need a liaison? I asked if we need a liaison for consultants and contractors. We talked about it, just bring it to the meeting. We'll choose one at the time. I put a note on here, do we really need to vote on all communications? Not vote, but we should discuss certain communications, but we already discussed all that. Got it.
I have one, Joe.
Yeah, well, yeah, we're gonna go around. I just wanna make sure I got all. Barb, I didn't miss any of your stuff either.
That's, yeah, nope, it's covered.
Got that. Got mine. Go through chairman. I'm good with mine.
When the commission wants a legal opinion, I think that that should come from a commission discussion. That going to open hours on your own, just for your own edification, is fine. But when the commission wants a legal opinion, it should come from a discussion of the commission, and Barb should then bring our voted upon question to Adam.
If it's outside, you mean if it's outside open office hours?
Well, I mean, for instance, if I went to open office hours and asked Adam some questions about a matter before us, and I bring what Adam tells me back to the meeting, that information that Adam has given me has not only come from him and the way he's presented it, it has also passed through my filters. We all have filters. And so if I come to the meeting and I say X, Y, and Z, that should not be considered the commission's legal opinion. We should directly have Barb go straight to Adam with whatever legal opinion we want to get, because we had a problem with this in the past.
I don't know if I
So,
agree with that. I mean, we have, the whole point of open hours is so people can go and talk to Adam for opinions. I know most of us probably have utilized it. I wouldn't want to stop that.
I wouldn't want to stop that either, and that's not what I'm recommending. I'm
what
just
is it?
saying that when we bring that back to the commission, if there's discussion, before we accept that as, and there's difference of opinion, accept that information as the legal opinion, we have Barb get an official legal opinion from Adam.
Can I
Adam-
comment, Joe?
Yeah, I just, real quick, I think, I do, before you comment, I do think it's valuable that people,
Yes, and I'm not
Adam's opinion
nothing I'm saying is limiting that in any way, shape, or
You're
form.
saying when they bring the legal opinion back, if there's like a disagreement or something? then we
Yes,
should
if the
get-
commission still has, that we, Adam, what do you think about secondhand legal
Well, what do you
information?
think, what do you amend the policy?
Yeah.
I don't know if that wants.
Well, I think Joan, the key word Joan used was filters. I mean, 3 people can go to Adam during open hours and ask him the same question, and they're going to hear Adam's answer a little differently.
Same
Right,
thing.
but they're going to hear it a little differently.
Mr.
And
Chairman?
I think what Joan is just saying, when the committee is looking for an official legal position,
Right.
it's up to Barbara to contact Adam.
I fully support, I think everybody supports the open office hours. I think they're a great thing. My personal policy is that if you want to bring something back to the commission as a result of that discussion, then you should get it documented by Adam and bring what he says physically back to the meeting. If you don't have what he physically says, I wouldn't even discuss it because, as you say,
Filters.
who knows what was really said or what filters were applied. So I think either, I think it would be simpler, because why, why go twice, right? I mean,
But
if,
the only thing
time
is,
you're paying for
the answer you get is very often predicated on the type of question you ask.
well, it should be a written question. It should be a written question.
Okay, if it's a written question, which we all know exactly what was asked.
Right.
And then we have a written answer, I have no problem
Right,
with that.
yeah. And that's usually why, I think usually council restates the question.
Needs to be specified, and the response needs to be
So you want this in the
specified.
policy to say
For legal opinions.
Hours of legal opinions, there needs to be a written question and a written answer
Yes,
to be brought to the table.
yes.
I'm fine with
Then,
that.
yeah, then if we don't like it, we can always take
Right,
another
discuss
step.
it, ask a different question,
Right.
write a different question, have
Right.
Barb go back to Adam.
Sure.
So if I could offer just
Yes.
one point of information. So, office hours can sometimes be both a blessing and a curse, right? I've had experiences in all communities where we've done office hours where I've given inconsistent opinions because I've gotten inconsistent information from different individuals, often from the same board, commission, it happens with some frequency. I'm asked for an opinion, here's what I know, I base my opinion on information. I'm always careful to caveat and say, well, based on what you told me, here's my thoughts, informally. But then I find out from another member of that same public body that, well, you weren't told this, and you weren't told that, and you weren't told this, and so there's a different opinion. So I agree and fully support the concept of written questions and written answers, because then you can see the paper trail. I also think it makes a lot of sense for efficiency that if the commission wants an opinion on which it's going to rely for some purpose, I don't mean, general off-the-cuff stuff by office hours and some guidance on this or some guidance on that, but you're gonna contract with a party and you need some advice on whether or not you can do it in a particular way. It makes good sense to have that discussion in an open meeting and to gather the information you need and to send a request through Barb, which of course then it goes through Heather, as all legal requests do to me, and for me to know that it's coming, the request is coming from the commission. I'm not suggesting you should attend office hours. I'm not suggesting that I won't meet with you in office hours or won't answer written questions that you submit to me in office hours or document it afterwards. But having all the information, knowing the information is coming from the commission as a whole, I think is important that these are important decisions that you're, or important opinions that you're going to be relying upon for decisions that you make.
And that's what I was saying, that, because even if we have a written question, when the commission as a whole discusses it, there may be additional pieces of information that we all bring to the table that may change the answer to that question if that piece of information was included in the question. So I think that while going to open office hours is fine, we shouldn't be relying on them as our legal reading on a policy that we're involved in, on an issue that is before the commission's deliberation. Because you may offer a piece of input I didn't think of, and now the question changes, and therefore the answer might
Yeah, I'm
change.
fine with that. I mean, I don't think we wouldn't go to open office hours for a actual legal matter within the commission. I think the reason we go to office hours is for clarification on certain simpler questions on procedures or policies or what to do, but not official legal matters that the commission are going to be looking at. So I'm fine with both. I'm fine with doing the written question and getting a written response just to say, hey, I just was curious about this. If anyone else was curious about it, this is what Adam thinks. And then if we have an actual matter of real substance for legal, yeah, we should all talk about it and go through Barb and Heather and Adam. So that should probably be, both of those points should be in there. Maybe we should have like a section on dealing with legal in this policy.
Also, it's just important to point out that on our council hours, there aren't as many council slots as there are commission members. So if several think that they want to go to a council hour, you may want to have a discussion and send one question.
Perfect, awesome.
Because
Good
you
point.
can't have, we
That
could
is-
pretty much fill up your afternoon. if-
That's a really good point,
We've also
that,
done 2 people before. We've also had 2 members go to Adam before.
at the same time? Mm-hmm. Yeah, and that's awesome, but I like what Barbara's saying. She's saying we should discuss it in a meeting and maybe decide Carl and John are going to go together on this issue, or, to keep it as a team effort. I like that, Barb.
Yeah, for any matter that would legally affect us, yeah, I would say that's fine.
Right.
But if anyone has just a curiosity or a question or something like that for Adam, then they should go, and if they think it's valuable to the commission, they can bring it and with a written question or written answer. And we don't have to really agree or disagree with it. It's just one of those things where someone can bring it and there's a public comment to say, hey, just so you guys know, I went Tuesday, I talked to Adam, and this is what he said about this. Take it or leave it.
Right.
So I think we're good there. Joe, what else did you have?
No.
Keep doing your thing. The alphabet. We didn't stop that. That was it?
Those are the bullets I have, but I have a general concern about chain of command of communications and Barb's time being spent on communications. I mean, I know
Right.
Barb has said that she's had some issues with some of her time being eaten up.
Yeah, so that, one of the agenda additions going through the chair will help with a good amount of that stuff. What other type of communications do you think need to be maybe filtered through somebody else before going to you? Because I know you get a lot of requests throughout the 2 weeks before meetings, and I know you can't get to every single one of them. But other than inputs and possible opinions when people aren't there, what else do you have?
It's quieter. If what's going to come at a meeting is funneled through the chair as far as what's going to be on the agenda.
It'll quiet
Yeah,
down to be
that'll
freed
quiet
up a little
down.
more. Does that
And then,
answer your concern?
yeah.
Whatever, I just want to make sure her needs are addressed.
Right. And just any, day-to-day tasks to be asked of me or of Jack that it's brought up at the meeting will help. If it's all
Ahead of
brought
time,
before.
discussed at the meeting ahead of
Right.
time, not individuals
Right,
going
as a-
to you on their own.
As a commission
Yeah.
request.
And most of the times, correct me if I'm wrong, Barb, but most of the times, these things are not emergency issues. And so there would be no harm in waiting to the meeting, other than you have to curb your own enthusiasm, as I did with the references for the irrigation meters. But I did, I waited, it wasn't an emergency. So I think that would help Barb, if I'm not mistaken, Barb, if we all could come to the meeting instead of just going to her and discuss it at the meeting, and then maybe we can send 1 or 2 people to find things out.
I'm just trying to figure out, I wouldn't want to restrict anybody, if they need to reach out to Barb, for other matters outside of an agenda. Is that what you mean? Just like bring it here instead of asking Barb? But because because Barb controls a lot of stuff and information that might be necessary for the next meeting. That if there's an agenda item on here, and say Carl sees that agenda item and says, "Oh, I remember we did this years ago," I wouldn't want to restrict Carl from
No,
going to Barb and asking for that information.
But if possible, and it can wait without,
Right, but that's what my idea, my example is specific to needing it for the next meeting. So you couldn't wait for the next meeting because it was necessary
For the next-
for the next meeting. So that, you wouldn't want to restrict anybody of getting information from Barb because she kind of is the keeper of all that type of stuff and knows where it is.
so only if information is absolutely
Yeah, if you
necessary.
need
before-
that information for the meeting, you should absolutely, if you need to go through Barb, you shouldn't don't go wait for me or anything like that. Go right to Bob for it. And I don't think you get a whole lot of requests like that. Especially not right now. I mean, maybe more towards like the budget stuff. It probably is more busy than it is now. But yeah, I wouldn't want to restrict anybody from getting information they need
We don't have a social media presence, right? Correct?
Not an official one, though. We don't have
We're
any,
on
we
a-
don't
we
have
have a
any.
website.
After today's open meeting thing, I don't think that's a great idea.
I know there's a lot of hoops you have to jump through. I don't even. No, we don't have one. No one would want to follow it anyway.
There is a DPW.
Yeah, you have one.
Page.
Yeah.
And would certainly be open to announcements or something.
There you go. If we
like
needed to do
that.
something like that.
I mean, details and policies might not be appropriate, but informational posts, I think, are good. And that should go throughout the whole department, cemetery, parks, sewer facilities. If there's something that comes up, right away I started to sort of focus on the big, as I posted the big impact construction projects, because people want to know, traffic, things like that. But if there was something that the commission wanted to post, now I don't, you go to Barb would come to me.
Yep.
Yeah. So, yeah, we don't have a social.
But to get your own page.
No, I don't think any of us want our own page. But
There's-
do we need a social media thing in here? Like, if we wanted to use Jack's page to reach, because that is an
It should
official
come
town.
through a meeting with a majority
Right.
consensus
That's- I
to
still
approve
can-
it.
It's not really third party, but it kind of falls under that whole don't represent the commission without the commission knowing about it type thing.
Well, and that's one of the things I was looking on here on Heather's thing. He said refrain from communicating sewer commission policy or position to anyone unless the full commission has previously agreed on that position and the language covering it. And I think that's a really important one. That's number 4 on the backside under Roman numeral 4. And I really like that. That's important to me, to refrain from communicating the position of the sewer commission to anyone unless the full commission has previously agreed on both the position and the language.
Yeah, but this was under relations with fellow commission members. This isn't, under this Roman numeral, it doesn't actually talk about social media outside of other
I'm not
commission-
talking about social media.
You're saying,
I'm just saying I like number 4 under 4.
oh, you're just saying that you like that?
I would like to see that in our policy.
Oh, okay.
That's all I'm saying.
Well, so this is, Heather, this section is relations with fellow commission members. So you're saying that commission members should refrain from communicating the position of the sewer commission to anyone, but this is specific to commission members, so I don't even know who anyone would be here, unless the full commission, but this is for commission members, has previously agreed on both the position and,
We'll just take 4
That
out.
could be under community.
me personally, yeah, I don't think it needs to be there.
That's
Okay.
better under community, yeah.
All right, yeah, that confused me, all right. I mean, I haven't read this obviously yet, so I'm a pain in the butt, so I'm sure I'll
Like if
have
someone,
plenty of edits.
if they were late on bills or something, like if a bill reminder, we could vote and have you go through Jack and maybe you can put like a,
Hey, reminder, bills
hey,
went out.
reminder, sewer bills went out. and
Barb does that, she does.
Yeah, we'd,
No, but he's talking about
we'd
through the
vote
social
to go
media.
through her,
Right.
she'd tell him.
Yeah.
Well,
If they
yeah.
ever need,
Yeah, I don't know if we'll ever use
Yeah.
that. But yeah, you'd have to.
That is on the
That's the
town's
process.
website, under sewer commission. I usually tell them
Okay.
when
Also, okay.
But that just,
bills are due and what's going to happen if you don't pay.
just for, because, Ryan's new here, maybe an opportunity. I'm not sure why that example would ever go to Jack.
No, that's what I meant. It won't go to
He
Jack.
means to post on
The
Jack's
DPW.
DPW
Okay.
Facebook
Oh,
page.
or if we're going to get into the social media.
Yeah,
Got
that's
it,
what
yeah,
he's saying.
all right.
I understand.
You'd have to bring it here first before
Yep.
you just tell Jack.
Us, Barb.
And I think it falls into the whole third-party thing.
Yep.
'Cause there should be some sort of social media bullet in here somewhere. And that'd probably be the only thing, because we're not gonna have our own
No.
social media. Maybe a Snapchat. We can go videotape all the gross stuff happening. Joe, any other bullet points you want to bring up?
No, I'm good. I like what Heather's written. I mean, I had an opportunity to scan it here, and I really like it. There isn't anything on here that I would take exception to. I think a lot of it is responsible, courteous teamwork with respect to every member's right to participate, and no one member thinking that they have any more pull or authority than any of the other members.
Okay. Who wants to go next? I'm looking for anybody who wants to do it. Do you have any bullet
I
points?
think everything I had's been covered, so.
Carl?
Well, one just suggestion we look at maybe is, I would suggest we consider adopting the Board of Selectmen policy on email
Speak up, Carl.
communication.
I'm sorry, I'm
I suggest we review and perhaps just incorporate the email communication policy from the Board of Selectmen.
Do you happen to have that?
I have a hard copy.
Well,
It's
but the only-
electronically available
The only thing
also.
is, Adam said that that policy wasn't up to the statutes. So we don't want to include something that's misleading because the state statute rules over the policy. Or do I have it wrong, Adam?
I think it was one specific sentence that Carl pointed out. but I
Yeah,
don't
there were
think it
3 words that you might want to
It wasn't-
adjust.
it
but
wasn't underneath
It's
the,
a whole,
you know.
it's a whole segment on communication email. I'm just saying, if we're talking about communication, there's, and I hate reinventing the wheel or having something special to one commission that isn't some, have our own little thing. I don't think we're that special. But we could adopt, other commission's policies. So I think one of the things we should do is see if there are any other policies available anywhere. I think it's come up before.
Yeah, or let's leverage-
On communications and leverage it. But the email communication one would be a simple one. It looks pretty reasonable.
Do we know what it says?
I would suggest-
What does it say? Yes, could you read it, Heather? Thank
How
you.
long is it?
It's a paragraph.
It's a paragraph, yeah.
So it's section 2.04 of the Policies and Procedures
Yes.
Manual, and that, you can find that on the website under the Board of Selectmen's page. Email policy by boards and committees. All governmental bodies within the town of Lunenburg should not exchange emails between a quorum, parentheses, simple majority of the board, committee, or commission, either on a collective basis or on a serial basis on substantive matters as a matter of abiding by the open meeting law. Distribution of a meeting agenda, scheduling, or procedural information or reports or documents that may be discussed at a meeting generally does not constitute deliberation, provided that when these materials are distributed, no member of the public body expresses an opinion on matters within the body's jurisdiction to other members of the public body. Communication among less than a quorum of the members of the public body will not be a deliberation unless there are multiple communications among the members of the public body that together constitute communication among a quorum of members. When members of a public body communicate in a serial manner in order to evade the open meeting law, this is a violation of the law. So it's essentially summarizing open meeting law in an email policy. Mhm.
Okay.
Now,
I
should
have
we,
no problem.
should we add anything in there? Do we need to add the regulation number or open meeting law number or anything like that? Because that says open meeting law, but there's open meeting law and there's also the regulation thing you were talking about. Should we add that regulation in there as well? Or just the word regulation or something like that?
You could say, right, so you could say as part of the first sentence, I don't know that it's a necessity. What you've done here is not just incorporate the law, you've sort of restated the basic premise of the law. And that includes both the statute and the regulations. But the first sentence reads, and I'll add something to the end, all governmental bodies within the town of Lunenburg should not exchange emails between a quorum of the board, committee, or commission, either on a collective basis or on a serial basis on substantive matters abiding by the open meeting law. You could say as a matter of abiding by the open meeting law and the regulations promulgated thereunder, which incorporates the regulations that have been adopted under the open meeting law. It's sort of 6 of one, half dozen of the other. Either way, the law is the law. That's what you're bound by.
Yeah, I'm fine with either way.
I'm fine with it
So
the way it is.
we'll just adopt the BUS then. Thank you, Ed.
Sure.
Thank you, Carl, for bringing that. Thanks, Heather, for reading all that.
So are we going to, I'm not making a recommendation here, I'm just making a request.
Also, I got a whole bunch of bullet points.
Okay. What about Heather's bullet points? Are we going to, what's the status of those?
We're going through Carl's right now, and then we're not gonna, I don't want to read all these through the night. We still have a lot to incorporate. I think this is the workshop to kind of get a good idea. I think at the end, everyone should take, Heather said she can send this as a Word document so we can kind of edit it, add what you want. I don't want to remove anything, maybe move things around. Maybe put in where you think the things we talked about should be in there after we get the notes.
After we get the minutes from tonight, because the minutes will have what we have.
Or notes of, a bunch of people are taking notes. I'm sure Heather could send us the notes and this is a Word document at the same time. right? And then we're gonna have to, I mean, we're not finalizing the policy tonight, so we're gonna have to go back and do this a couple more times.
So will it be on the agenda next time, or?
Yeah, I'll have to take a look at how big the agenda is for next time, but it'll be on that agenda in July at least.
Okay, thank you.
Yeah. Okay, all good.
The general area of, that we have no communications, and we're delinquent and have been for my whole stay here, so worse than everybody else.
I'm sorry, I can't hear you, Carl.
My concern is communications as it relates to the business manager and our role as the co-supervisor. And we don't get any communications in that regard, and I think that's a whole big gap that we have for communications.
What do you mean by, like, reviews of performance?
Well, yeah, I mean, what goal setting, reviews, even, I know one of the big issues that Barb has at the end of every year is comp time, but I don't know, I don't know how that's communicated when overtime is taken and therefore comp time is scheduled, how that approval process is. So there's a whole communication regarding our role as a shared supervisor here that we're missing, and I'm wondering how we get communications on
Are
those.
we her supervisor?
Yes, we are. Well, us and Jack.
I would disagree with that.
Would you like me to read her job description?
Well, I'm going off the charter.
Her job description says,
Supersedes the charter.
her job description says reports to DPW Director and Sewer Commission, and supervision says work under the general direction of the Director of Public Works and the Sewer Commission. And that's when the position was created, when I was there, and Barb was hired. That was the job description that we needed, and that's what we need. So we need to be a little bit more active. And on the communication side, what should be communicated?
Well, I think Heather said she disagrees with you, so I think we need to get a clear understanding here, because you have one opinion, she has another.
I don't have an opinion, I've got a job description. It's not an opinion. We can change the job description, and we can go through all the town charters and all that, but we have regulations today, we have job descriptions, and we're trying to create new things that we're undermining our basis, so we don't have no base to work with. We shouldn't be creating any policies then, right? I mean, we're on pretty smushy ground if we don't even agree that this job description is correct.
Let's see what Heather has to say.
Well, and correct me if I'm wrong, Adam, but the charter would supersede any contradictory bylaw, any internal procedures, such things as the job description that would lay that out.
Not the problem then.
I agree, but the charter is not clear on it. The charter is under great debate, so it's not. So if we defer to that document, we're in real trouble, because that's very unclear in terms of responsibilities.
Well, I did receive a legal opinion when I first came to Lunenburg, because some areas, I believe, I agree, are gray in the charter and could be defined in greater detail. And the opinion of legal counsel, who's our labor counsel, was concurring that such things as personnel-related things are under the jurisdiction of the town manager.
Oh, so that's different than what I was saying.
But personnel meaning performance valuations. It doesn't mean that consultation wouldn't be appropriate or even solicited for information, but...
Okay, it's a start. I mean, that's communication to me, and it's something we don't have and haven't had in 12 years. So that would be a start. That at least, if that's clearly we don't do anything with the performance review. So, so a start would be visibility to what is being done. And one thing that does affect us and affects our customers is the work schedule, and the when overtime is taken, when comp time is taken. That affects when our job gets done. So those are things that we need to participate in some level, and what that level is, and what we call everybody. But the Sewer Commission, the Enterprise Fund, our customers depend on certain jobs that Barb has to do on behalf of the Sewer Commission, not on behalf of the day-to-day, but on behalf of the Sewer Commission. We need visibility into those aspects, what the goals are in that area, what the performance is, and not that we have to do it, we can do it collaboratively, with the DPW director. That would be what I would expect for a shared responsibility. But we have no communication in that regard now. I don't even know, and I can't find out what the process is, and maybe you could inform me tonight, Barb or Jack, what the process is for scheduling overtime and scheduling comp time, what the authorization is, because we quite often we can't get our job done sometime because of these issues.
Barb, are you in the salary admit plan?
Yes.
Then there's a whole document there, Carl, about, and I don't think it speaks to comp time.
Yeah, it doesn't. I've checked that plan. That's why I'm saying I can't find it. I
can't find it,
I
yeah.
can't find anything that says
I know
how it gets authorized, how it gets approved. I find things in the policy that says a lot of very firm things about work time. It has to, but I can't find anywhere that administers it. And I'm not getting into writing those policies, but I'm just saying that those things affect our operations of the sewer department. And we need communication and we need visibility to those. And if we don't think that this job description is right, then we should be working on that too. I don't know. I don't know, but it's a piece of communication that we don't have at all, and I would like to see us get addressed at this time.
So if I understand what's been said here, and I'm trying to make sure I'm clear, Heather has a legal opinion from a labor lawyer that she is, town's labor lawyer, that she is in charge of Barb's personnel, issues. And Carl is concerned that the sewer commission needs input into some of that because billing, et cetera, affects our workings.
Mhm.
Okay.
Yeah.
Does anyone?
Barb's availability affects what we get done.
So do either of you have a suggestion on what would be a good way to solve this problem?
Hold on, John, if you don't mind, I'll run it. Does anyone disagree with what Carl is saying?
No, I don't disagree
No?
with what he's saying.
No, I don't disagree.
Okay, so my opinion personally is, so we have this job description was written when this whole position was opened up.
Yeah,
So, the sewer commission at the time was under the impression that there would be shared responsibilities here. I don't think it's a bad idea for maybe me and Jack to sit down and figure out how we can do that, how we can consolidate or maybe talk about things like that. I don't know if, and then maybe I can write up a little brief paragraph of what we talked about and bring it to the meeting that we talked about, this communication workshop, and we can kind of dissect it then. If everyone's okay with that, I can do that. So I would like I would think me and Jack would sit down and figure out how we can kind of communicate these types of things, because it does affect us. And then maybe me and Jack can write up how we can, in the future, go forward with exactly what Carl just said, with comp times and overtimes and things like that, and reviews or whatever. Because I think we deal with the business manager a lot, and it makes sense that we would have something to say in that regard, and I don't think we ever have. That's my opinion.
I think that's a good idea for you and Jack, too.
Who hired Barb?
Well,
Okay, time at the time.
Yeah.
Hires and the appointment is ratified by the charter.
Yeah, I mean, especially if you ratify the appointment, you should have a say in what's going on. What's your opinion?
I think the charter is pretty clear about segregation of some duties. I think, and Adam, weigh in when you feel necessary, because it's creating a separation of day-to-day operations and maintenance and policy-making boards. And to me, that's a little too much into the day-to-day of management of the town employees that are paid town employees.
I'm not saying we're gonna be deciding on PTO time or anything like that for Barb specifically. I'm just saying in general, there should be something. Are you saying there shouldn't be anything at all?
I'd like to hear some, a preliminary draft first before,
I'd like to have Adam weigh in, just so that we have a clear idea on what is legal.
So I'll weigh in briefly, but I want to say a couple of things. I'm not going to weigh in on the labor components of it because I don't deal with personnel matters. That's why you've got separate labor council. The charter is clear in some respects, and in other respects, it leaves a bit to be desired. What it is clear upon is that day-to-day operation, care, and maintenance of the sanitary sewers is not under the supervision of the Board of Sewer Commissioners. It's under the supervision of the town manager. What it's clear about is that appointment of the sewer business manager is not the power of the Board of Sewer Commissioners, it's the power of the town manager. I understand that it's subject to ratification. That exists in many other areas of the law where there are appointments that are subject to ratification, but the ratifying authority is not the appointing authority. The ratifying authority has the ability to say yay or nay, but ultimately the appointing authority is the appointing authority. So I don't think there's anything wrong with, and I defer, this is my opinion and not a legal opinion, I don't think that there's anything wrong necessarily with there being open communication where you've got the sort of scheme that you've got here, where you have a Board of Sewer Commissioners that is responsible for the policy making, the decisions that...
Resources in the charter too.
What's that?
It does say resources
Yes,
in the charter.
absolutely. So I recognizing that, I think that it's appropriate that there be some communication between the sewer commission and the town manager, between the sewer commission and the DPW director. I think that makes good sense. Where you draw the line between communication and the sewer commissioner impeding upon day-to-day operation, care, and maintenance of the sanitary sewers, or the appointing authority and the personnel decisions per Labor Council's opinion with regard to the sewer business manager, I think that's probably a fine line. And again, I'm not going to opine on the labor component of it, but I do think that the clear day-to-day operation, care, maintenance questions are questions that are left to the town manager, and to the extent that the business manager handles those sorts of matters, the business manager is the town manager's appointee. But there's a bit of an overlap here, and there's a bit of a separation of powers, and I think that's intentional. I don't know the source of the creation of that structure that goes back to many versions ago of your charter, but I suspect it was intentional.
So what's our role?
Policy.
Yeah, mostly policy.
It's not that simple. It's not that simple.
Budget, we're in charge of
the word-
I can read it. It's a simple paragraph. You want to read it?
Yeah, go ahead.
The Board of Sewer Commissioners shall make careful studies of the resources, possibilities, and needs of the town as they relate to the availability of sanitary sewers, and shall make plans for the installation of a system of sanitary sewers and for the maintenance of a sanitary sewer system. The Board of Sewer Commissioners shall develop a comprehensive or master plan for a townwide system of sanitary sewers, setting forth in graphic and textual form policies to govern the future growth and development of the entire town. The Board of Sewer Commissioners shall, in conjunction with other land use bodies, assist in developing a long-range strategic plan for guiding town growth and development. The powers and authority of the Board of Sewer Commissioners shall include oversight of the Sewer Enterprise Fund, setting rates and charges for the use of the sanitary sewer system, ratification responsibility for the sewer business manager, and providing advice to the Board of Selectmen relating to the intergovernmental agreements concerning sanitary sewers. That's from the charter.
If I can read another section of the charter as well. This is related to personnel, and this is under the powers and duties of the town manager. And it is section 4-2, paragraph E. To be, and this would relate to Barb because she's part of the salary administration plan, to be in conjunction with a personnel board established by bylaw entrusted with the administration of a town personnel system, including but not limited to personnel policies and practices, rules and regulations, including provisions for an annual employee performance review, personnel bylaw, and collective bargaining agreements entered into by the town, and to prepare and keep a current plan establishing the personnel staffing requirements for each town agency unless some other provision is made by law.
I think in the past where we have gotten into trouble is where we try and get involved in some of the day-to-day. And while I think it's important that we communicate our needs for billing, et cetera, and I think it's important that Barb be treated fairly and get her comp time, I'm not sure that we're in charge, after hearing these things that Adam and Heather have said, I think that we might want to meet with Heather if we have a concern and discuss it with Heather. If some of our needs are not getting met, our needs that have to be met are not getting met, I would think that the commission could discuss that in an open meeting, and that we could have someone go and meet with Heather to express our concerns. I would encourage Barb, if she's not getting her comp time, to meet with Heather, because Heather's her personnel director, evaluator, and Barb should speak to Heather about that directly. I don't think that's our place as a sewer commission. I don't think that has anything to do with the well-being of the sewers in town. So that's what I think. I think that if we have a concern about Barb's performance and it's affecting the sewer commission and our service to our customers, we should discuss it in an open meeting and then come to a consensus and have our chairman meet with Heather to work anything out.
Okay, and that's not a lot different than, Joe, what you had suggested, you and Jack meeting.
Right.
So the difference is we talk about it in a meeting, and either you can meet with Jack or you can meet with Heather and see where we go from there. That's
Fine with that. I don't think it's ever gonna happen. Bob, just keep doing good stuff.
Sounds right.
What other bullet points that we didn't touch on yet?
No, just to clarify, when you meet with Jack, we'll talk about, to bring us back to communications, of what would be communicated, what information should be communicated, and,
So, based on Bob's role?
yeah.
So I think what John was saying is if there is a need to talk with Jack, we would all talk about it first, and then I would go to Jack with it.
Or if,
Oh, I thought,
or
Or
if it ends
Heather,
up being,
because
or
Heather
which-
is,
Heather,
from what I've heard
bottom
tonight,
line,
Heather
what-
is personnel, right?
She appointed Jack.
Yeah, she appoints, so she delegates that authority to Jack.
Right, so I would think I would go to Jack, unless Heather wants to know everything that's going on.
Fine.
Yeah, I assume you would. If there was ever an issue, yeah. I don't see there being really a problem. But after reading what you just read to town manager, yeah, we shouldn't really get involved too much in the performance stuff like that. If there is an issue, yeah.
well, I think that is an issue. If we don't, if we have no input to performance or goals or
We don't.
objectives, then I think that is an issue that,
Then we have to bring it up with the charter review committee.
Right.
I agree with what you're saying with the job description.
yeah,
but Heather
okay.
just read it, and it,
yeah, I guess maybe the letter of the law is correct. What bothers me is the message that's being sent, that the town doesn't want to involve the commission in performance reviews and inputs to that.
I don't think that's
what I'm
true.
hearing, and I'm hearing that
No, I don't
everybody
think
here
that's
is
true. I'm
fine with
just-
that.
no interrupt, just let him finish his sentences and.
Okay.
Go ahead.
I think what we're saying is that if there is an issue, we'll discuss it at a meeting, and then our chairman will go and talk to either Jack or Heather about it.
Okay, so you
That's
didn't
what-
hear what I said. My concern is not that, is not what you just said, because that's fine.
that's how we have
My
input.
concern is that the message is being sent to the community and to all the volunteers out there and to all our users, is that the town is not sure that they want to involve the commission that is responsible for getting this done and responsible for the financial enterprise fund, involving them in the review process and the goal-setting process. That's a concern to me as a citizen of the town. It's not unique to the sewer commission or anything else.
I don't disagree with you, but we're not gonna fix that tonight.
No, I just wanted to make the statement that I'm very disappointed.
What else? Yeah, for the communication policy, real quick.
Well, I guess the thing is when communication, maybe something nobody wants to touch either. But when information is requested, it's not clear that there's a good process, and maybe we need to identify it. When information is requested of the business manager, what the process is for responding to that request for information.
Or process to respond to you, if you're requesting information?
Well, to anyone, but
No, I mean, just in general, like if you sent Barbara an email requesting information, we don't have currently right now a procedure or policy saying, like a timeline of when Barbara needs to
well,
respond? or
I'll
if
give you
Barbara needs to
the
respond?
example. I had a personal request, nothing to do with the sewer commission, for some information, public information, that I requested Barb. Barb.
Public stuff goes to clerk or Heather.
No, I mean, you don't have to go through the open,
I know,
the public information request
you mean, like,
information.
as a
You can,
resident?
you can pick a call, you can ask somebody for
As
some
a resident,
information.
like on sewer, went to the business manager for a question. Is that what you mean?
As a resident, requested some information.
Okay.
And somebody made a decision that, no, don't provide it, make them make an open meeting, whatever.
Freedom of information.
Public document request, public record request, thank you very much.
Is that me? Did I say that?
I don't know who said it. I asked Barb, and she wouldn't tell me who said it.
Tell Barb to blow you up all the time.
Whoever,
Wondering if it was-
it's not a good process, I don't think to,
So as a resident, it wouldn't be into this communications policy anyway, unless we
Right.
put something in for Barb, if Barb needs to answer every single email that comes to her.
well, I thought we were talking about communications of this
Of the
commission.
commission itself, I don't know if we were coming up with the communication policy as to what Barb needs to do to residents. I think the communication policy
Is for the
what we need
commission.
to do as commissioners with each other.
Right, right.
I understand your concern, and maybe that's just something we should bring up as an agenda item in the future for something like that, as a separate, but that would probably be something more for Heather or Jack about when do you want Barb to provide information and when you don't, because I don't think that we would tell her to answer emails or not. You know what I mean?
Right.
If I'm not
'Cause that's
answering,
Yeah, no, I
if
don't-
I'm not answering emails at work,
I don't think
my
anything
boss
here-
tells me, hey, why aren't you answering that email that person sent you? It's not going to be, it wouldn't be us. I wouldn't think.
So to be clear, then, the whole intent of this whole communication thing is strictly to define what the commissioners can and cannot do and not go outside of,
Not right now. Right now, it is just the commission, the commissioners. But I have no problem opening that up, but I think it would be a different.
Can we finish one thing first before we open it up?
Be a different.
okay,
What else?
that's it. I got-
You got it? Ryan, you ready? Yeah. You good? Jack, anything that you think we might have missed?
Not that I'm going to bring up right now, I don't think. I think you gather all this, whosever task it is to put it together and get everybody's ideas and get a rough draft for everyone's opinion. Might, reserve the right to offer one. If you feel it's appropriate, I do so.
Nothing outside of what I provided the commission.
Bob, did you think of anything else while we were going through all that stuff? Okay, so Heather, you said you can send us, this is a Word doc and the notes that you took tonight that incorporated everything. And we'll do exactly what Jack has said, we said we're gonna do. We'll do it, kind of edit this and, read through what editor has you want, and we're gonna have to have probably another workshop on it. This is gonna be probably a larger discussion than tonight, because the next move would be hopefully vote on an actual policy, or at least re-edit and then have a plan to vote on a policy. So I'm gonna close this agenda item. Thank you for everybody coming out and helping with that.
Agenda. Do you have an agenda? Do you have a personal agenda? Where are we?
We are at FY19 flow assessment contract, sewer commission signed. Bob, you have that?
Yeah, I just have, it's for FY19. We received it. It was part of our budget process. Came in, just needs chairman signature. That's the same one that's been, they've offered, come in at
Good
the same
job.
price, right, for multiple years, so. I've also talked to him, and hopefully we'll have him come in August.
I signed
Oh,
this.
excellent.
What do I sign here? This thing?
Yeah,
I gotta write all this stuff.
just sign.
sign.
I'll fill it in. Just,
Where am I, a witness?
no, you're not a witness.
What am I saying here?
That first line under town or Lunenburg.
Bye.
Right,
That's what I just signed there.
yes, please. And then the only other item is this commitment for Q3. When I was doing the preparation to send it up to the accountant, there was a math error.
Q2 or Q3?
Yeah, Q3. Oh, did I put, yeah, I know,
It says Q2
sorry.
on the agenda, so it's
It is
Q2
Q-
FY18 corrected commitment.
It is the Q3.
Okay, sorry.
Corrected commitment. And it's not a big difference, it was a difference, but the one you signed previously was 174,704, and this is for 174,579. It was
So it's just an error in
an
accounting?
Excel formula thing, so if you could,
Oh, we all gotta do it?
Yeah, we all gotta sign that one.
Twice?
Twice, yes, there's two sites.
See?
And then,
We're learning. 12 years
come
ago, we're
alive.
learning.
Ryan, you don't need to sign this, because it's dated,
No, this one.
oh no, that one. It's dated before you came on, so. Because it's always dated the date the bills were sent out.
You want to read it? Here it is. Okay. Okay, don't you sign it. And
And that was all I had.
that's all it is. Member agendas, inputs for a future meeting. Anybody have anything right now?
I have two.
Got two, go for it.
I would like to be able to give a report on July 10th on what I have gleaned and learned from the references that I checked for the irrigation meters.
Needs to be July 10th?
Oh, that's when you weren't at the last meeting, that's when people said it would be, but they wanted me, I said I would have it done by then, but
Okay, that's fine.
that's, I mean, I don't care. The other one is, I just want to remind you that I am making two small revisions to two small areas of the grease trap rules and regulations, and I will have my suggested revisions ready for July 10th. I thought that I was supposed to have them ready by then. Barb's shaking her head yes. Have I remembered correctly?
Yeah,
Yes?
July 10th is our
July
major
10th.
policy.
So I will have both of those ready, so I'm hopeful that I will be able to present those. This needs to go to John.
Anybody else? Agenda inputs? John, no, Carl?
I do have one, but the references that we're checking, Joan, just so we get to July 10th, is this for both of the companies?
Only one company provided us with a list of references. So I am checking the list of references for that company. The other company did not provide us with any references. If you would like me to call them and ask them for a list of references, of course, I wouldn't do that without commission approval.
That's why I bring it up.
You know, I mean, I can try and get some from them. But one company provided us with 4 municipalities, not individual people, municipalities. When one, it was the billing person from one, which is great because she talks about how they interface with billing. It was, you know, a DPW from another. So I'm just pursuing what I was given, which is what I said I would do at the last meeting.
Yeah, we should expand that to include the second.
I would like to suggest that,
Do you want me to call him and
we
ask
vote
him
to
for
have
the list
him-
of references? I have the folders still. They both
Yeah.
had information on contacts in there.
I'm sure they'd be happy to.
I'll call him and ask him for some
Yeah.
references.
Great, thank you.
No problem.
You know, by July 10th, but
Oh, it depends how fast he gets them to me.
Yeah.
if you have them by July 10th, will you let me know so we can put, just so the agenda is clear of what we'll be talking about?
I will most definitely do that.
Thank you.
What do you need to know, Joe?
48 hours.
More than that.
By Thursday,
It needs to be
3 days, 3 days.
Has to be Wednesday.
Thursday before, the Wednesday before, the Thursday before.
Oh, that's actually the 4th of July.
Try my best. I will definitely have the first 4 that I was asked to get last time done.
Appreciate that, thank you.
I'm not sure it'll fit on that one, maybe it's on your ongoing list, but in our DPW, not DPW, DEP, in these letters, report, we had talked about doing some data analysis and things, and I'd like to get that going, which takes an agenda item and discussion of how we get that going.
DEP,
This is what we talked about, getting an
the-
independent person in to look at the data.
Yeah, that first step of the submittal we did.
send me an exact wording of it.
It's the third project on the
Yeah, it's the
last
third
page
project on the
of
project
the
list.
table. That Weston is.
Where did I see fit? And so July 10th is pretty full already, though. So I might have to
Yeah, I don't know it needs to be on that one, I just want to get it on your list, because they kind of
keep bringing it
bubbling up. But what I would like to get on there, because it may be timely, is a discussion on our annual fees. I'm a little concerned about the Asian Imperial, and I'd like to have the commission review what transpired there, and because our regulation may need to be clarified, but it relates to the fee we seem to have charged Asian Imperial for the annual permit.
Okay. John, you said no, right? Right. You good? I got nothing, Ryan, anything? Any public comment?
I've got a comment, if I could. Going back to an earlier agenda item, you've got a selectman watching who made a correction to a statement that I made earlier, so I'm going to correct it for the record. So there's a question asked by one of you about whether or not there was a requirement that meeting minutes be posted. and file with the town clerk. It might have been you, Joe. And indeed, there's no requirement in the statute. I was confident of that. There's a requirement in your bylaws.
Oh.
So you've got two separate bylaws. You've got a bylaw, Chapter 5, that addresses records and minutes that requires them be filed with the town clerk within 2 weeks of them becoming public, which is essentially when they're voted on, or if they're executive session, when they come out of executive session. And then you've got a further requirement in, I think it's Section 60, that requires the town clerk, once she receives them, or he receives them, to post them to the town's website.
So my question was specific to open meeting law, would be an open meeting law violation, which it would not be, right?
No, but it would be a violation of the bylaws if you didn't file them with the town clerk, and if the town clerk didn't post them, he or she would be in violation of the bylaw.
Of the bylaw.
Right.
Which I wouldn't, well, I don't know what you do there.
Just saying.
All right, thanks. Thank you, Selectman, who's watching, who we all probably know this. Anybody else for public comment?
I do, because I guess I came in late to your meeting when you already discussed this item on the agenda for the legal expenses.
Oh, yeah.
So this is, I'll pass that along. It's just a letter I drafted regarding legal expenses, and I can read it. Dear Chairman Anderson, this letter is to request that the Sewer Commission revisit the payment of legal costs for the Sewer Commission's use of town council retroactively to July 2017. As an enterprise, these costs should be borne by the enterprise and should not be paid out of the general appropriation for legal expenses. The Finance Director, Karen Brochu, and I came before the Commission on January 30th, 2018 to discuss this topic, and the concern raised at that meeting was that our current retainer agreement with Town Council, Mead, Tellerman, and Costa, may create a situation that the Sewer Commission was paying up to the entire monthly retainer if the Commission was the sole user of Town Council for that respective month. This was based on a calculation of taking the monthly retainer amount, dividing it by the total number of hours used by all departments, and multiplying that rate by the number of hours used by the Sewer Commission. Attached, you will find a calculation of billable time attributable to sewer with the fluctuating hourly rate using the above formula. As you can see, the initial month was elevated by the average hourly rate was approximately $199 for a total cost of $5,319.42 from July 5th, 2017 until our last billing cycle that we received as of May 20th, 2018. The Sewer Commission budgeted $7,000 for legal expenses for fiscal 17 and $5,000 for legal expenses for fiscal 18, respectively. In fiscal 17, the Sewer Commission spent $5,117 in legal expenses and has spent $2,414 in legal expenses payable to KP Law to date for fiscal 18. As authorized by a vote taken by the Board of Selectmen at their August 8th, 2017 meeting, the Sewer Commission was granted authorization to continue using the town's previous town council, KP Law, for the Highfield Village legal matter for an undetermined, finite time. I would also recommend that this arrangement be revisited to discuss transitioning this matter over to our current town council. Thank you for your attention to this matter, as I feel it very relevant to the taxpayers of Lunenburg. Respectfully, Heather Lemieux.
Hey, I have a question. These dates here, are these for individual letters that the commission as a whole sent to the attorney, or do these include open hours that Sewer Commission used to turn?
Individual responses, and all the bills related to Sewer Commission's use of Town Council, MTC, have been forwarded to this business manager, so those should be on file.
I haven't gotten them all. I just got the most recent one, but I hadn't gotten anything since like January, so if I
All
can.
right, I have copies of all of them, you can see, but they are all attributable to issues that were followed up by Town Council.
I'll just add only one point of clarification, which is, so we've itemized, the majority of the services we provide to the town are under general government category. We itemize certain types of services, one of which is services provided to the Sewer Commission. What we don't itemize are office hours. And so office hours are billed under general government because it's something we provide sort of regardless of who shows up. So if there may be 1 or 2 or 3 commissioners or your business manager that books time, I'm going to be there regardless. So we bill that to general government. So that's sort of the one exception to the rule. There is regular participation by your commission in portions of those office hours on a monthly basis, and going back to the latter part of last year on a bi-weekly basis, which is how we sort of ramped up to get familiar with the town, and those have not been billed separately. So it's only been specific tasks that have been performed for the commission, and because we itemize our bills, and even though we're on a flat fee, we include travel in itemizing our bills, we've also deducted travel. So for example, I won't be billing the commission separately for travel tonight because I'm already here for office hours anyway and would be. So those go under general government together with the office hours, and all you get billed for is the length of time that I'm here at your meeting.
If I may ask the chairman, what was the discussion and action taken on that agenda
There
item?
wasn't much action taken. Carl wanted to review the numbers, and that's what we decided.
Yeah, so this is helpful, because this is one of the things that I was going to look for to review the numbers. What I don't understand is, from our discussion before, there was some discussion of $1,000 and things. I don't know how that relates to this, Barb.
Right, this was, at the meeting in January, I did not come away with it feeling that the commission was prepared or had prepared for fiscal year 18 to pay based on the discussion at that meeting. That was my takeaway from it. We had set up a purchase order at the very beginning of fiscal year 18 to cover legal expenses, and it was $1,000 that PO was sitting there. Beyond that, and we have $1,586 that I was planning to encumber for KP Law before your request here, because we're waiting on the finalization of John Fitch Highway numbers. So it's not KP Law that's dragging it out. It's kind of, we're waiting on Fitchburg. So we had 1586 for KP Law. We had 1,000 just set aside originally before we knew how it was all going to pan out with MTC. And then there's another 1,000 that's sitting in our legal counsel. So my question to the group before you came in was just, in our end of fiscal year, did we want to do something with that money towards the work that Adam's done for the commission? So Carl had just said, let's put it on the encumbrance and talk about it at the next meeting when it's supposed to be finalized. So a recap.
So based on our discussion before, although we don't have our communication policy in place, I'll ask for permission to check with Barb if I need some more information, which I think I do. I think I have the budget and all that, but I might need to get some more information from Barb on this story and what we're committing to KP Law, where we are with them. I think one of the information is right here, saying 5,000 was the legal in our budget for FY18. That's easy to check. But I'd like to have access to Barb to get the whole story together.
If you need information for that type of stuff, you go to Barb. You don't have to,
Okay. So we should be able to resolve that at least understand it.
So,
But it sounds,
earlier we said you put it on the next meeting. Bring this up again and
And I can forward those, any missing, or Lane can.
Okay. Yeah.
Once you don't have on
I
file.
remember getting them for the January, but I don't think I've gotten like February, March, April. I got just the most recent, that 136. I think I have it here just
the 136.
for the discussion. But
When, out of curiosity, when we have the last number, so we know what the total comes up to?
Haven't received the bill.
But when will we receive it?
For end of fiscal year?
Yes.
Yeah.
Until January.
So we generally bill, our months are a bit unique, and we do it because so many of our clients are municipalities and it works with their warrants. Our billing month goes from the 20th of one month to the 19th of the next month. So our bills usually go out on the 20th, 21st, 22nd, sometime around that time. At the end of fiscal year, what we typically do for our municipalities, unless they ask otherwise, is in addition to sending an invoice out at the end of June, right around the 21st, 22nd, we send a further invoice for the remaining 10 days of the fiscal year right after July 1, usually on like July 2, so that it covers the end of the fiscal year, and you don't have to wait until the very end of July to get a bill for the previous fiscal year.
Right, okay. So we'll have a number, we'll be pretty close with the base number, and then
By the end of next week,
at the
you'll
end of
have the
next week,
final
we'll have the whole
numbers.
thing. Super.
okay, so
Yeah, that's great. Yep.
All right, thank you.
take a motion to adjourn.
I move we adjourn.
All in favor?
Aye. Thank you. Thanks, Adam. That was very helpful tonight. Really appreciate it.